I guess thank you, Co-Chairman. Co-Chairman Dalton kind of went over the ground rules in here yesterday. It looks like it's going to be pretty tame in here, but just be respectful with your comments and direct your questions to the chairman and then through him to the representative. And we'll start off here. Let's just go ahead and do roll call this morning. If that's okay, Katie.
Good morning, Mr. Chairman. This is roll call for June 12th, 2026. Senator Crago?
Excused.
Senator Love?
Here.
Senator McEwen?
Here.
Senator Pearson? Here. Representative Davis?
Here.
Representative Fornstrom?
Here.
Representative Johnson?
Present.
Representative Ottman?
Here.
Representative Provenza? Representative Schmid? Representative Strzok?
Here.
Representative Winter?
Here.
Co-Chairman Banks?
Here.
Chairman Ide. We have a quorum.
Thank you. So first up on our agenda this morning is, let's see here, where's my schedule? Wyoming Food Freedom Amendments.
Hello. Here, try that.
Here we go. All right, we'll start that over again. Wyoming Food Freedom Amendments be the first item on our agenda this morning, and Anna Johnson will come up and go over those to draft legislation, and we can discuss that when she's finished. Thank you.
Good morning, Chairman, members of the committee. My name is Anna Johnson. I'm a staff attorney for LSO. I've got two bill drafts here. The first one is entitled 27 LSO 46, Wyoming Food Freedom Act Amendments. And so you should have both of these bills in your packet. Beginning on page 2 of the bill draft indicates that commercial food establishments shall be authorized to use unpasteurized milk as an ingredient for foods sold by or consumed in such commercial establishments if the informed end consumer is given notice in writing by the establishment that the unpasteurized milk has not been inspected or pasteurized. On page 4, the amendments would allow a producer's designated agent, or a third-party seller to sell meat products from animals raised by the producer and that were slaughtered on the producer's facility or at a custom slaughter facility. The staff comment on page 4 indicates that the Federal Meat Inspection Act prohibits direct-to-consumer sales of uninspected meat by a producer-designated agent or third-party seller. While the Wyoming Food Freedom Act could be amended to allow these types of sales, the sales themselves would be in violation of federal law unless and until the requirements of subsection O printed in the bill draft are met. So basically, there is some federal legislation that might end up passing in the near future called the Prime Act, but as of right now, that hasn't happened yet. Depending on the requirements of hypothetical federal law contemplated in subsection O, designated agents or third-party sellers may or may not be able to sell a producer's meat products regardless of the amendments that we make to subsection N. So it would kind of depend on what would end up in the federal Prime Act, whether or not that would be allowable. And then beginning on page 5, the staff comment indicates that the Food Freedom Act uses the terms designated agent and third-party seller somewhat interchangeably. The committee may wish to consider allowing third-party sellers to sell meat pursuant to subsection N or amend the definition of designated agent to include third-party sellers. But that would be a policy decision for the committee. The two terms are used throughout the act exclusively and could or should be construed to mean different things. And then there are two conforming amendments on page 6. And at the bottom of page 6, the Department of Agriculture is given rulemaking authority. That's the gist of that bill, and I would stand for any questions.
Committee. Questions for Anna? Ms. Johnson. Go ahead, Representative Johnson.
Thank you, Mr. Chairman. Thank you, Anna. Thank you for working on this bill for me. I know it's a rough draft, and we're just going to try and work through it and see if we can make it better. I think we all know that we want to be able to have food freedom and not be encumbered by a lot of rules. So the first thing I had was the meat. And I wish maybe we can address this later, but Y-Fresh, the county inspector, Laramie County, made the producer of that meat sit in front of that locker to sell the meat at Y-Fresh. Other than that, that was the only thing I didn't understand the logic of that, because if you're a corporation, you already have an agent that's going to sell meat for you. The corporation isn't there to sell the meat the whole time. So I would like to see what we can do to address that. And let me.
Chairman Ide, Representative Johnson, I can't really speak to individual instances of or individual cases, I guess, regarding the Food Freedom Act. I can't really get into that or give advice based on that. But I think by making the changes where it wouldn't just be a producer, by adding designated agent or third-party seller to the wording of the of subsection N in the Food Freedom Act might fix that problem. Or at least that was the intent, to fix problems like that. But I mean, I guess we could talk to the Department of Agriculture too when they get up here.
Okay. Thank you, Mr. Chairman. Also, we're looking at the trigger bill, that it's passed the House of Representatives, but not the Senate. And then it needs to be signed into law. So
No, we're testing. There you go.
is that better? All right.
Go ahead, Representative Johnson.
So there's also the Direct Act of 2025, and it's S3099, which allows meat processed in a meat plant to be sold over state lines on the internet. And I'm wondering, maybe we could look into that and see. I'm thinking maybe if Y-Fresh just had an internet connection there, somebody could come in there and order their meat and then go over to the locker and pick it up. I mean, I think the people want it to be easy to shop and to get the things that they want. And I think that there's some rules that are written in that are maybe needed, that we can find a way around some of them, is what I'm hoping for.
Chairman Ide, Representative Johnson. So federal law constrains a lot of these things. I will look into that act and we can talk about it at the next meeting too, or I can give you more information just one-on-one on that in the coming month or so before we have the next meeting, but I could bring information about that as well. And yeah, we can look into it and see what we can do.
Yeah, thank you. Thank you. And I think we're just getting our information today. We'll go from there.
It's just a quick question, follow up on Representative Johnson. That Prime Act was put into the Farm Bill. As I understand, it was amendment to the Farm Bill. Representative Massey from Kentucky, I think, got that in there. And it has passed the House of Representatives. Is there any timeline, do you know, on when it goes to the Senate? And yeah, thank you.
Chairman Ide, I'm not sure when that will go to the Senate. I think we'll just have to keep an eye on it. But I will be monitoring it.
And one more quick one on that. So we actually have a Prime Act that passed the Senate and House in Wyoming. And that's a trigger could you explain that a little bit, what happens there? Thank you.
Yes, Chairman Ide, members of the committee. So basically, we do have essentially the Prime Act wording in subsection N of the Food Freedom Act. What that would allow is to allow meat sales that from either uninspected meat or meat that was butchered at a custom slaughter facility. So basically, within the state, producers would be able to sell meat that's uninspected if the Prime Act passes federally. Right now, it's still illegal under federal law, but if the Prime Act or something similar passes, then when that happens, producers in Wyoming would be able to do that.
So I have a meat department. I have a meat department that slaughters meat. And that's all it does. Does that qualify as a custom slaughter plant? And if not, why not?
Chairman Ide, Senator McEwen, do you mean you have a butcher at your grocery store, or do you actually have like a slaughterhouse? Is that, I guess I just need a little clarification.
I have two butchers, a saw, a grinder. I get inspected regularly. I pay for that license too. I don't understand the difference between that room and a custom slaughterhouse. In fact, that room is tiled. It has a drain, separates fat through the drain. It's actually probably a little nicer than some of them. So I'm just curious, wouldn't that be a custom slaughterhouse?
Chairman Ide, Senator McEwen, from what I understand, a custom slaughterhouse would be somewhere where the animal is actually slaughtered and butchered and basically dressed at that facility. So it wouldn't necessarily be like where they take a dead animal to the butcher and dress it there. It would be the entire process from slaughter to butcher to.
Yeah, I think I'd either call it a butcher or meat cutting shop.
Chairman Ide, Representative Johnson, so custom slaughter facility, I believe, is actually a federal definition. And so if the Prime Act passed, it would apply to custom slaughter facilities, but not necessarily like butcher shops and things like that. I think it would depend on the circumstances, what would fall under the federal law. And right now, there's just so many hypotheticals because we don't know what's going to pass. We don't know how it's going to match up with Wyoming law. So, I mean, right now, all I can really give you is hypotheticals.
Senator McEwen.
I guess I'm confused because I think this is for cleanliness and healthiness, right? Yet I can pull a trailer around, go to your house and cut up your cow outside, and that's all good, right? Mobile slaughter plants?
Chairman Ide, Senator McEwen, I think that might be a question for the Department of Ag.
Thank you.
Mr. Chairman, through you, so I've had the privilege of working in a couple different facilities over the years, helping some friends out. One was a state inspected plant. One was a custom shop. And there's a lot of little nuances that I'm afraid we're missing as a committee right now. And we need to work through those ideas. And when you say a custom shop, you're talking about a location, whether they field slaughter and they show up at your house, they kill the animal there, haul it into the shop, and then process the animal in the shop. Whether they take delivery of the animal, it's killed on site and processed in their shop. That is a custom shop. In order to then have a third-party sale in the state of Wyoming right now, if you want that to happen, that animal has to do one of those two trips. When it gets to the custom shop, then you can have a state inspector show up at the time of processing and killing to make sure that everything meets our requirements for the state. Our state has great stringent requirements that actually are far and above the USDA requirements in many cases. From there, once you process that animal, somebody like Senator McEwen can buy box beef from that animal then because it's certified, inspected. It can go to his shop, he can cut it, sell it third party, do whatever he'd like, and everything is fine. As a meat processor and somebody that raises beef and sells halves and quarters of beef, I have to sell an animal at a certain point. And so when I sell one of my colleagues here a half a beef, I sell them the animal. I've delivered the animal to the processing plant. They then pay for the processing themselves and obtain that half of beef. And so they owned the animal before it was harvested. And so it's just a lot of little nuances that I'm afraid we're trying to work through in this process. And having a better understanding of that would be great. And I'm sure our Department of Ag folks can help educate us on that.
Thank you, Senator Love. And you kind of hit on it there at the end. I think the Department of Ag might be a good place to have answers maybe on those questions.
Mr. Chairman,
Yes.
just to comment, I believe CWC's here as well, and they had a mobile plant, so maybe they can join in on that as well.
Very good. Yeah, I'd like to bring them up. Anybody else, committee? Just one last thing on it. We always defer to federal law. Always bothers me. We gave them all of their enumerated powers, and we act like we're sort of the stepchild of the federal government, where we're really the boss. How do those federal laws, as far as compliance to those, where is that power? We always hear the Commerce Clause, and can you elaborate on that anywhere? And can we just not comply and nullify them? Thank you.
Chairman Ide, so basically, you would find that power by the federal government under the Supremacy Clause. A lot of these things are preempted by federal law under the Supremacy Clause. So basically, if there's a federal law that can Senator Ide, I think a lot of this comes down to nuance too. Generally, more current case law would indicate that if there is a conflicting federal law with state law, then federal law would supersede it. We can have a discussion offline though, too. I'd be happy to. Right.
Senator McEwen.
I'd like to push back a little on what was said earlier. I've been trying to do this for 12 years. The health inspector actually told me if I had a mobile slaughter plant, I could cut the meat up in my parking lot, just not in the grocery store. So I guess I need an answer if that's true or not.
Chairman Ide, Senator McEwen, I am not positive on that. I think maybe, hopefully the Department of Ag will be able to answer that question.
Representative Strong.
Thank you, Chairman. I guess the only thing I'm going to throw out there, I really would like to know if we have our own laws and what can the federal government do to us? I know I probably shouldn't say that online, but I really would like to know, what do they do?
Chairman Ide, Representative Strzok, at the very least, I think people could end up with some fairly hefty fines and injunctions and things like that. So.
Thank you, Ms. Johnson. Appreciate your commentary. Oh, yeah, go ahead and go over it. Yeah.
We do have another bill. It's in your packet, right? It should be right after the Food Freedom Act Amendment 1. It is entitled 27 LSO 40, Department of Agriculture Rules Cost Benefit Analysis. This bill draft was suggested by Representative Johnson. There is a staff comment beginning on the bottom of page 1 that indicates that the bill draft appears to be duplicative of the newly enacted Wyoming Statute 28.9.109 regarding the monetary analysis that has to be done regarding major rules. The committee may wish to consider amending that statute and having it apply to all rules, not just major ones. However, that would probably require LSO to need additional resources. And then beginning on page 2, the bill draft amends Wyoming Statute 11.2.202 to require the Department of Agriculture, when providing an initial notice of a new rule or regulation, to provide an estimate of the monetary cost that will be incurred by the state or any other person to implement and comply with the rule or regulation, and a description of the rule or regulation's benefit to the public. And then on page 3, the bill draft has an effective date of July 1st, 2027. And I would be happy to answer any questions.
Representative Johnson.
Thank you. Is it working? Thank you, Mr. Chairman and Anna. This rule, it kind of tags along with the recent law that we passed in this last session. There's a cap for a major rule needs to be $1 million. So as long as it doesn't cost more than $1 million, they can move any rule they want. But that rule might put some producers out of business. I mean, they don't make $1 million. So I'm just wondering if we can lower that limit so that that Department of Agriculture has to notify us of any rule changes that affect people monetarily and the department. Is that?
Go ahead.
Chairman Ide, Representative Johnson. So this amendment that I'm making in this bill draft doesn't have a cap. There's no monetary value. They have to basically, under this bill, they would have to disclose any monetary cost, no matter the amount.
Go ahead, Representative.
Oh, okay, thank you, Mr. Chairman. Thank you, Anna. So there's no cap. So any rule change, even if I would say it'd make a minor change, they would notify people involved.
Chairman Ide, Representative Johnson. So yes, basically under this bill draft, when the initial notice of the new rule or regulation came out, that would be included within that notice.
Good with that, Representative?
Yes, Mr. Chairman, I think that's what we want.
Okay. Any other questions from the committee for Ms. Johnson? Thank you. Okay, let's move on here. I think it's probably time to bring up the Wyoming Department of Agriculture. Guys, come on up. Whoever wants to start.
Yeah, thank you,
Madam
Mr.
Buck.
Chairman. Good morning, committee. Doug Miyamoto with the Department of Ag. Joe Budd, the Deputy Director of the Department of Ag, is with me today. I will try to answer some of the questions that came up earlier about the Federal Meat Inspection Act and corroborate some of what has been provided in information. I'm happy to try to answer any other questions that you may have about that as well. It is extraordinarily complicated, but generally talking about, the bill drafts that you just reviewed. I mean, there's been some recent developments in the state of Wyoming, of which I think you're all aware, within the food safety program of the Department of Ag that I think is germane to the discussion of these bills. So if it's all right with you, I would like to start with the general overview, and then we can get into specific questions and answers about that proposed legislation. Does that work?
Very good.
Okay, thank you, Mr. Chairman. Yeah, I'm happy for this opportunity because I think there's been some misperceptions and some misinformation about what the Department of Ag does and why we do it and what happened in these recent instances and how that all came to be. So just glad for the opportunity to fling the shutters back on this entire situation and just let you know what happened and why we responded the way that we did. So we received these documented complaints both in Cheyenne and in Cody about the sales of meat without a license. That's the primary reason that we were in any of the establishments as of late. We had photos and video that was submitted to us in the form of a complaint that said we have meat sales going on in these communities without a license. And so now you're coming back to our state program in compliance with the Federal Meat Inspection Act. If you want to sell meat, then you have to have this retail food license in the state of Wyoming. And so that's the reason that we went in there. The Food Freedom Act itself, this would be Wyoming Statute 1149-103, subsection C, Romanet 4, shall not involve the sale of meat products. And then there are some exceptions that are attached to that within the Food Freedom Act, but it's important to note none of those exceptions applied in these instances. So exceptions that are in the Food Freedom Act didn't apply in these cases. And so that's why we went ahead with these inspections. Meat sales without a license are also not compliant with federal law. Under the Federal Meat Inspection Act, there is a requirement for us as state departments of ag or any other state department of ag that has a state meat inspection program. We have to agree to maintain a program that is quote unquote same as or equal to that of the USDA. And so that's the contract that we have with the USDA, that we're going to provide the regulatory assurance that our meat program is going to provide the same level of safety as the federal act does, either by doing it the exact same way that they do it or by providing a program that is equal to. almost all states, there's 27 states that have a state meat inspection program, and none of them do it exactly the same way that the feds do. They don't use their software. They don't require all of the same things in the facility that the feds do. It's generally much, much cheaper to get state inspected meat facility compared to a federal one. Federal USDA inspected facilities are typically more expensive to set up and run, and that's why a lot of people opt to come under state inspection, but it does limit you as well. So anyway, why is it that meat sales require a license? This is part of the Federal Meat Inspection Act that is in place for three primary reasons. The first one is if we don't license a facility and USDA issues a recall for that meat product and we don't know who's selling it, we can't institute the recall. So that's why there's a license for anybody that's selling meat. If they issue a recall, we can contact those retailers and say there's been a recall for this lot number of beef or whatever it happened to be, and we can issue a recall that way. But if we don't know who's selling it, we wouldn't be able to do that. So that's part of the requirement. The second requirement is under the banner of misbranding. We have to ensure at the point of final sale for delivery to the end consumer that that meat product hasn't been misbranded. So this is a topic that this committee has discussed in recent sessions as well. We've talked about country of origin labeling and the requirements and hoping that we get, some mandatory country of origin labeling requirements that come back into USDA. If that happens, we have to maintain a chain of custody to make sure that label is not changed or tampered with all the way from slaughter until it's delivered to the end consumer. If there's a labeling requirement, somebody has to do a compliance review and go out and say, all right, they're following the rules when it comes to country of origin labeling. Check, it can legally be sold. So misbranding is another reason why these facilities that sell meat have to be licensed. And the third one is we have to prevent adulteration. These are all terms that show up in the Federal Meat Inspection Act. And if we don't have access to the facility, if we don't know who's selling that final product, we can't go in and inspect because we don't know who's doing it. So we can't guarantee that the product isn't being adulterated from that standpoint. So those are the things that we have to keep in place in order to maintain our equal to standing and maintain our state meat inspection program.
Go ahead, Representative Hoffman.
Thank you, Mr. Chairman. Mr. Miyamoto, could you please just give me a explanation or clarity on adulteration?
Go ahead.
Yes, adulterated would mean that that meat has been tainted by an item that is not wholesome. So there's a list of adulterants in a lot of federal food safety regulations, and if you commingle that meat product or mix it with something that's on the adulterated list, then that would make it ineligible for sale. Okay?
Go ahead.
All right. Point number 2. None of the stop sales that we issued in any of these cases had anything at all to do with raw milk. I want to dispel that myth. Raw milk wasn't a consideration in what we did. We were initially informed that we had an entity that was selling breakfast items that contained meat, and they didn't have a license to sell. So essentially, if you want to open a coffee shop, you want to open a restaurant, you want to sell things commercially, you need a license. Subsequently, we learned that the entity was also selling non-homemade grocery items and prepared food items like breakfast burritos, and they didn't have a retail or commercial license. That's the reason we were there. Statute requires us to stop sale of non-homemade food items without licensure. The Food Freedom Act itself, and I've been around for the evolution of most of the Food Freedom Act, but it draws a pretty bright line between homemade and commercial food items. If you read the act itself, there's a pretty distinct line between the eligibility of selling homemade items versus what's required for commercial food items. If the items are truly made in a home kitchen, they can be sold under the act without licensure, without inspection, and they can be delivered in a myriad of different ways that are all outlined in the Food Freedom Act. That's if they're produced in a home kitchen, but that's not what we were talking about here. I want it to be clear, though, to the committee today, the Department of Ag would have had the same obligation if pasteurized milk had been used in lattes. We still would have had to issue the stop sale and say, if you want to sell coffee, if you want to be a coffee shop, then you need to have a commercial food license in order to open a coffee shop. So we would have had the same obligation whether that milk was pasteurized or raw. That didn't play into us having the obligation under statute to say, you can't do this without a license. The other point I'd like to make is in defense of our inspectors.
Take a quick question here from Senator McEwen. Sorry to interrupt you.
I know you don't want to hit on raw milk that much, but I do have a couple questions there.
Sure.
You can sell raw milk at a farmer's market, correct?
Yes,
But I can't sell it in the grocery store.
correct.
Even if I label it as raw milk, consume at your own risk.
Correct.
And the coffee shops can use it now if they give you the warning.
Incorrect.
There's a few of them that think so.
No, so raw milk is eligible for sale as a farm product directly from a producer to an end consumer, but it can't be brought into a commercial food establishment or used as an ingredient.
Okay, thank you.
Just real quick on that, but pasteurized milk can.
I'm going to defer to my more legally trained cohort here.
Mr. Chairman, if I'm understanding the question correctly, you're asking where raw milk can and cannot be sold in pasteurized milk, and in the coffee shop context, what happens is that if you become a commercial or retail establishment, you would then fall under the food safety rule, which incorporates the pasteurized milk order, which is federal, which, back to the adulterant thing, the feds consider raw milk to be an adulterant, which then would put your commercial food license in jeopardy. So it's this huge catch-22 if you're trying to make a raw milk latte. So
Interesting.
clear as mud, I know.
Yeah. Make it as hard as they can on us, basically. Yeah. Go ahead, Senator McEwen.
I guess I'm kind of confused. I can bring in locally grown produce, which under my food license, and I'm not breaking the law. I can bring in chicken eggs and things of that nature. Those are probably just as dangerous as meat and raw milk. Well, why did we lighten up on those and not everything? Thank you.
Go ahead.
Mr. Chairman, Senator McCune, not sure quite how to answer that question other than to say the overarching federal laws define things differently and have eligibility for some products that is different than others. When I get into these discussions, I try to maintain the discussion about what the law requires of us and not go very far down the path of food safety, because for me, that's not the primary consideration. I have to just make sure I'm carrying out the statute. So associated risks and all of those things, those can be argued forever. But the reality of it is different products are treated differently because they're defined differently in various laws from our standpoint.
Go ahead, Senator.
And I don't believe that you're the driver behind all this, and I'm not upset with you. We used to have a saying in the Army, those jokers, except for it starts with a B, up at platoon. I get it. It's the overarching federal law. And I see that shifting if it gets through the Senate. And I'm trying to be proactive what that'll look like in Wyoming. Thank you.
Yes, thank you, Mr. Chairman. And, you know, I think I've testified to this committee before, but I'll repeat it again. If there's changes at the federal level, whether it has to do with the Prime Act or whether it has to do with one that I've been pushing for a long time, which is eligibility for interstate sale of state inspected product, meaning that if you had a state inspected facility, right now we're constrained from being able to sell that across state lines, even though they've said, well, your program is equal to that of the federal program. Well, if it's equal to it, why are we constrained from sales? Especially when foreign countries are also held to that equal to standard. So if you're Argentina or any other country, if you achieve the bar of equal to, just like we as the state of Wyoming have achieved that bar of equal to, Argentina can sell beef in any state in the United States, but Wyoming can only sell it in Wyoming. So that's been something that Mr. McGagna and many others and I have been working on for decades trying to get that changed. But I can assure this committee that if there's a change and if there's amendments to the Federal Meat Inspection Act, then that will automatically change our state program. And it will change the bar of what's required of us to maintain our equal to status. So that's where we're at with our federal laws. But going back to this initial or this overarching,
Senator, we got a quick follow-up. Thank you, Mr. Mimo.
Like I said, I've been trying to do this for many, many years. My question is, why can't I get a trained meat inspector, a state meat inspector, and put him on my payroll or her on my payroll if they're properly trained? Why do they have to work for the government? Thank you.
Mr. Chairman, Senator, again, federal law. Or maybe federal regulation. I'm not sure if it's indicated directly in the law, but the only authorized folks in the Federal Meat Inspection Act that I'm aware of are the only inspectors that operate are either USDA or state. But can't give you a better answer than that. It's always been that way, at least in my time in ag policy.
Follow-up.
Go ahead.
Do you see a path forward to fixing that? I mean, you know how easy it would be for me to wholly comply if I had my own inspector?
Mr. Chairman, Senator McCune, I just don't know. I'm sorry, I don't have better information on my crystal ball, especially when it comes to meat regulations. Isn't very clear. Well, Mr. Chairman, the way that I can tell you this, the way that the state of Wyoming, if you're a state inspected facility or you're a USDA inspector, they give you what's called a bug. And a bug is a carcass stamp. So you've seen usually, you know, this stamp that goes on the primal cuts or on a carcass that says either state inspected or USDA inspected. If it doesn't have that bug on it, it technically isn't eligible for sale. And if you put that bug on it and it's not legitimate, I think that could be a very expensive trial.
Senator Love.
Mr. Chairman, through you. So one of the reasons that you're not allowed to hire your own inspector is because it needs to be a third-party inspection, an independent operator that is there to uphold the regulatory burden of the state in protecting the people. If you're the one paying this individual and they're doing your inspections, it creates the opportunity for corruption. And so that's the whole idea behind there. And I think to go back to another question that was made earlier about being able to buy produce and eggs and things like that, when we look at the way God has packaged things and handed them to us in life, the egg retains its full packaging all the way to the point of sale. So does the skin on the fruit or the skin on the vegetable. And so it's therefore considered that you can wash off any external issues that have shown up and consume that somewhat safely, where meat is removed from the package, the skin is gone. Raw milk is no longer part of the package that was given to it naturally. And so I think that natural distinction, the biological effects of of how we harvest things and the way things are grown is the reason that those things fall under different categories than others. Thank you, Mr. Chairman.
Thanks, Senator Love. Yeah, just hit on that too, not to keep interjecting here, but that's what you just described is kind of the opposite of our discussion yesterday on preg testing, where you could hire the people, and if they worked for you and they were on your payroll, they were allowed to do it. But if it's a third party, so-called against the law, would that be fair to say?
Yes, Mr. Chairman, I wish I could detangle the conflicts for you, but unfortunately, the more that Joe and I research all the different states and their approaches to a lot of the cottage food industries, it is extraordinarily complex. I would agree.
Once again, and I think you'd agree with me, most of the recalls and passage of disease or illness have actually come from produce rather than meat over the last 2 years. So it might be packaged perfectly and still be rotten inside or have something wrong with it. So I don't quite follow that logic.
Go ahead, Mr. Miyamoto.
Yeah, thank you, Mr. Chairman, Senator. I tend to agree that when you get into food safety regulations, there's always these analogies that you can come up with, and it's one that's similar to, do speed limits save lives? Well, we have speed limits and people still die on highways, so you could argue no. It's the same thing in food safety. You have these various standards that are laid out. Do they prevent all illnesses? Do they prevent all outbreaks? They sure don't. So yeah, is there perfect consistency, and is it always a defensible position to take as a director of agriculture? It isn't. And, but I would tell you that system is far from perfect, but it may be the best one available to us. Generally speaking, we do have a very safe food system in this country, so that can't be ignored either, in my humble opinion.
You good?
Good.
Mr. Chairman, just to go back to your comment on the preg checking. So when we try to commingle these things, it gets really confusing. But in preg checking, if you hire somebody and that person works directly for you and they preg check your cows, the person that pays for the consequence of that decision is you. Where in this case, if it's removed from the package and sold to a third party, an unsuspecting public, the person that pays the consequence for that price is the public and not the producer. And so that's the very distinct difference in those two things.
Yeah, thank you, Senator Love. I'll just go back to my comment from yesterday where it's caveat emptor, let the buyer beware. Thank you.
Mr. Chairman, thank you. Couldn't have said it better myself. Okay. I want to make sure that the committee understands, and I think you probably already do, but WDA's inspectors are liable if they're aware of statutory violations and they fail to intervene. So if we go into something and we know that it's not compliant with statute, and we don't do anything about that, and then the worst happens, we're going to feel that. That's going to be something that we're going to find ourselves on a witness stand at some point. And so the reality of it is, in a lot of cases, we have a statutory obligation that, leaves us with very little wiggle room in these instances. I want the committee to also know that, in these recent instances, this wasn't the first time that we had received complaints about various entities, but the reality of the situation is, if those aren't verifiable complaints, if they're not legitimate, we don't intervene. We have several complaints that if it's just hearsay and we don't have anything more compelling than that, we're not going into those establishments. We don't consider ourselves to be detectives. We're not investigators. We're not doing those things. We respond to a complaint in this case, go in and see if that's something that is valid and then deal with it in the gentlest way possible. So in these recent instances, what we did was went in there and said, you can't continue these sales unless and until you have a license. But we didn't issue any quarantines, and we didn't destroy any products, and we didn't pursue any heavier regulatory mechanisms. There was no fines that were issued or anything like that. And so that's the path that we've decided to take. We're trying to do this, and if we can get it done voluntarily, we'll do that. Now, we have had demands for contested case hearings in response to this. We've had owners of these entities that demanded a contested case hearing, and I want to be clear, we did respond to that by submitting that request to the Attorney General's office and basically saying, what's our obligation here? And I would just want to inform the committee, when it comes to these requests for contested case hearings, we as the Department of Ag or any other department, we don't really have the authority to either grant or deny a contested case hearing. It's one of those scenarios where an entity is either eligible for a contested case hearing, in which case they get one, or they're not eligible for a contested case hearing. So it's not something that we have any decision-making authority over. I can't, as the director of the Department of Ag, say, I'm going to grant you a contested case hearing, but I'm going to deny you, because that's what I feel like. There's a series of qualifiers, and it says, if we suspend a license or we issue you a fine, you're eligible for a contested case hearing. So that's how that scenario played out in these instances of food safety. And I'd just leave you with this, at the end of the day, I'm good with the way that our inspectors and our agencies responded to this. I think, I've had a lot of discussions with our inspectors, and I know Joe and I have discussed this ad nauseum, and I think we can all sit here and tell you that as uncomfortable as it is to come and talk about some unpopular statutes or regulations that we have, we would much rather do this than be a defendant in a court proceeding because something went wrong and somebody asks, why didn't you carry out the clearly defined statutory obligations that you had as an agency and you just chose not to do that? How come that is the case? And then I'll leave you with something that I was part of that regulatory reduction task force, that legislative work group that occurred a couple years ago, and worked on that as well. And I told that committee the same thing that I'll tell you today. And that is, when it comes to food safety, it's a difficult program to try to administer because there's so many variable opinions about the right way to do it and the wrong way to do it. But after having done this for some time, I would tell you that the penalty for failure when it comes to food safety, while it's rare, it's exceedingly harsh as well. And so it's something that we have to keep in the back of our mind, that the penalty for failure in food safety can be severe. So I appreciate the time, and I know that Joe he had researched the language in the proposed bills. We have some thoughts on those. Generally, for your consideration, from my standpoint, when it comes to eligibility of raw milk availability or eligibility in commercial food establishments, I would urge the committee, we did some research on this, and there's some states out there that do allow for some sales of raw milk in a commercial setting, and I would urge you to take a look at those states. A couple of them that popped to the top for us was, there's examples that you can learn from in Maine, in Washington State. There's one in Pennsylvania. There's some others, but Joe and I did some reading on this as well. When it comes to the administrative procedures and, rule reviews, I think for me, I go back to trying to come up with fiscal impact notes when it came to new programs like hemp regulations. That one was one that happened as a result of the 2018 Farm Bill. We had to promulgate some rules around how we were going to administer the hemp program. And we always have to do a fiscal impact note, as you guys are well aware. And it is very hard to determine the level of adoption that might occur as a result of any change in rule or regulation. And so I can't sit here and tell you that I can give you very good information if I'm going to do a cost benefit analysis of any rule change within the Department of Ag. The fiscal impact note that we prepared in the hemp program, we initially based our estimate on a presumed participation rate of 200 applicants. The highest we ever had was 38. And today I think there's a half dozen. I mean, so our analysis was kind of pitiful, but that's just generally speaking. So Joe, if you have any thoughts on the legislation specifically, appreciate you allowing me the time to go over all of that stuff. A lot of good information from Senator Love. Generally speaking, one last thing, custom exempt is one that gets confused a lot, but keep this in mind. When it comes to custom exempt processing facility, the custom exemption is an exemption that was written for ranchers. And what it said was, if you're the owner of livestock, you don't have to have the same level of inspection because you're maintaining the risk of ownership. The liability is all yours anyway. Who are you going to sue if that carcass was tainted in any way, if it was diseased or anything else? You were the original owner of that animal. So you're exempt from daily inspection of the processing of that carcass as long as you go get that carcass back and use it for personal use. So you can't sell it, but you can take that back into your house and you're allowed to, use it for personal use. Employees, family, non-paying guests. That's what personal use means in the guise of the Federal Meat Inspection Act. But custom exempt, all that means is there's an exemption from all of the inspection for ranchers. That's how I would simplify it in my mind. That's an exemption that was written for ranchers. Okay?
Thank you, Mr. Miyamoto. One quick question before we move on. When was that Federal Meat Inspection Act put into law nationally?
Mr. Chairman, I think it was, when was it? 1906.
Yeah.
It's been amended a lot
Yeah,
over the years.
thank you.
Yeah.
Go ahead.
Mr. Chairman, I guess it's your pleasure on which order you want me to walk through these?
Yeah, well, go ahead and state your name and your
sorry.
position if you would, please.
Joe
Then
Bud.
we'll just start and we can go with the one we started with first and then go to the next one if that works for the committee. Yeah.
Sounds good. Joe Bud, Deputy Director, Wyoming Department of Agriculture. So I believe you started with the longer one, which amended portions of 1149-103. And I'm on page 2 of the bill, line 16. Would just point out to the committee here that commercial food establishment, as it's defined right now, would include any restaurant, it includes restaurants, schools, nursing homes, etc. So using that language here would then put unpasteurized milk as an ingredient into virtually every facility that exists. I believe this becomes a problem for you when you get into the definitions in Title 35, which specifically exclude producer to informed end consumer, which then confuses your bill later as well. So I just wanted to point that out for you to look at there. I think most of the staff comments covered the other things that we would talk about within this bill. The portion on page 6, it's probably line 3 through 7. The addition of designated agent, third-party seller within this portion, I don't believe that does what you intend it to do. This is still saying that these people are not included in the definition of commercial food establishment, which then conflicts with page 2 where you're trying to include them. So just a couple things there where I think the different portions of your bill are actually conflicting with each other rather than supporting each other. The last piece that I would note for you here is again on page 6, and it's lines 14 and 15. And this has really been part of the core issue and or just one of the things that we go around and around on a lot. The shall not apply to producers selling food directly or through a designated third-party seller. The producer is always the seller. that doesn't change. The delivery mechanism changes. And so delivery is a key term for us. It's not transaction. Transaction is very narrowly defined within the Food Freedom Act. It's buying and selling only, doesn't include donations. Delivery is defined. And so really on this piece, your designated agent is delivering the product. The producer is still the seller because that keeps your producer to informed and consumer chain intact. And that's been a key issue in a lot of the instances that we've dealt with lately. Happy to work with the committee and LSO on some of those things, but really wanted to point that out that when we have conflict in any of these instances, it comes down to whether it is a resale, which is not allowed, or it's just a delivery through an agent. So.
Thank you, Mr. Bud. Questions from the committee? Look like any. Yeah, that would be good to, you didn't suggest maybe language on that, and maybe Anna can help us with that after discussion with the department. Does that work for you, Anna?
Mr. Chairman, definitely, yes.
Okay. Go ahead, Representative Strong.
Thank you, Chairman. Okay, so with what we've put in here, so the scenario, I don't have the farmer's market per se that I sell my milk at and the cream. So if the lady that has it decides she wants to start making lattes with the raw milk, she won't be able to do that because I'm not the one in there doing it. Is that?
Go ahead.
Mr. Chairman, this is one of those that comes down to the details. If you look at the letter that went back to YFresh, we tried to put this into not YFresh, but to Hippie Cow. We tried to put this into a flow chart or kind of something that you could follow easily. So if you sell your raw milk to another person, you can sell it as an ingredient and they can take it and make it into a homemade product. It all comes down to whether it's homemade or whether it's retail. And so if it's producer to informed and consumer, and that person uses it as an ingredient in a homemade product, we don't have a problem. We wouldn't even know because we don't inspect those things, right? So when it moves into a retail setting is when it becomes an issue because you have to have that commercial license, which would then kick you into the food rule, which then makes raw milk an adulterant under the federal regulations. And that's the catch-22 I was describing earlier. So if it's all in the homemade world, we're good.
Okay. Committee, anything else? Senator Love? Senator Johnson?
Thank you, Mr. Chairman. And Mr. Bud, I've got your letter here that you sent to Hippie Cow Creamery, and it's on the second page, first paragraph. The Wyoming Food Freedom Act defines homemade foods as food that is prepared and processed in a private home kitchen that is not licensed, inspected, or regulated. The raw milk being used to make the lattes would be an ingredient of that homemade food, but not the final food product itself, because the entirety of the food process does not occur in a home kitchen. The final product, the latte, cannot be considered homemade food. Well, to the average person, that just seems like, I think it's ridiculous. You already know that you're going to go buy raw milk, raw cream, and if you want that latte, I think that's the sort of language that we want to clear up. I think the regulatory burden is what we're discussing. We want to make this simple. The Wyoming Food Freedom Act should make it simple, and the consumer understands the risk. That's the most important part. That I don't care who you are or what you do, government cannot protect you from everything. And so at some point you have to take risk in life. So I think I'm looking forward to working with you and making some of these. I mean, this just doesn't make sense to the common person. And And I look forward to working with you and straightening this out as much as we can. Thank you.
Mr. Chairman, Representative, I'll weigh in on this one a little bit because, well, I think both Joe and I spent a lot of time thinking about this one, but what it boils down to essentially is, with the Food Freedom Act, if it's produced in a home kitchen, it's eligible for sale under the Food Freedom Act. If it is produced anywhere else, it's not eligible for sale under the Food Freedom Act. So in the case, I think it boils down to, simply put, the way we're interpreting this is, if you want to open a coffee shop, it's not in your home kitchen, you got to have a license to do that. If you want to open a restaurant and you're not producing those items in your home kitchen, then you need a commercial food license to do that. That's as boiled down as it can be. And again, that's not wading into the food safety aspect of this at all. It's just a very sterile review of the existing statute and language.
So that's what we need to fix.
Yes, go ahead. Yeah.
Anybody else, committee? Go ahead, Representative Davis.
Thank you, Mr. Chairman. Just a question and maybe an observation, when we're talking licensing, is that a specific license for a restaurant, or is that a retail license, sales tax license? What type of licenses are we diving into here?
All right, yeah, so there's two of them for the purposes of our discussion today. If you were a grocery store or something like that, that's not serving any, prepared to order foods, if you were just doing some sales of already packaged products, that requires a retail food license. And then if you are going to open something like a restaurant or a coffee shop, that's where there's a commercial food license as well. So those are the two various licenses that you can get.
Go ahead.
Thank you, Mr. Chairman. I just want to ask you a question. If you have a license, what protection is afforded to the consumer through that license? I mean, it's just a tax, and I would just like to make that simple distinction that maybe we don't need licenses for the Wyoming Food Freedom Act.
Well, yeah, Mr. Chairman, Representative. So the purpose of the license, we are obligated to do at a minimum an annual inspection for sanitary conditions and for the facility itself. There's certain elements that are required for licensure. And so a separate sewer drain is one of those items. A 3-compartment sink is another one of those items. You have to have hot water and indoor plumbing. And so there's facility requirements that we're checking for. And then when we go in and do those inspections, we're looking for, is there vermin? Is it clean, generally speaking? Do we have grease buildup? Is there anything that might be considered a threat to the consumer because it's just not sanitary? Does the refrigerator get cold enough to store food safely? Does the freezer freeze? That's the kind of review that goes along with the licensure. General sanitary conditions and functioning of the operation is what we're looking at least on an annual basis. If there's problems, then we'll revisit that and make sure that those are taken care of. But that's how we view the purpose of the licensure.
You good with that, Representative Johnson?
Yes, Mr. Chairman, thank you.
Thank you. Go ahead, Representative Strong.
Thank you, Chairman. I was just curious, we had talked a lot that there was a lot in this that we needed to work on. Is this something that have we covered everything that you were worried about earlier? We had spoke a couple months ago that there was a lot of things in there. Or is just this kind of hitting the top and then we're going to continue working on it?
Good question. Thank you. Go ahead.
Mr. Chairman, I think that we have skimmed the surface, no pun intended, on raw milk producers. And the rest of the Food Freedom Act has a lot of problems, in my opinion. It makes it very hard to implement. And I think if it doesn't work for the public and it doesn't work for the agency, that's a law that's not working at all. So happy to work with you on whatever you want in there, but there's a lot of issues with the whole thing. Not the content. It's a lot of structure, and it kind of steps on itself a few times, which for our inspectors and our division that administers most of these things makes it very difficult for them to, one, interpret it, and two, do that consistently and fairly across the board.
Thank you. I don't think I totally really have a comment. I mean, a question, but more of a comment. Is this something that we all should form a little committee and work with the department rather than spending all day picking this apart and working through this? And because this isn't, what I understand, this won't fix till we meet up in during session anyway. Unless this is going to help our Hippie Cow now and some of the other places, I don't know, as if, just a question, is this something we really want to dig in and do right now, or form a committee and get things worked on through the fall?
Yeah, good comments, Representative Strzok. Yeah, that's kind of where my thoughts are going on this too, to a certain degree. I mean, you guys are out there inspecting, and we need to know when, the next landmine's going to hit here. And we want to truly broaden freedom with the Food Freedom Act. So we're not here addressing situations every time, and broaden this thing as wide as the sea, so everybody truly does have food freedom. Thank you. Senator McEwen.
I would be remiss for not pointing out that chicken and pork are treated differently than beef. And pork typically is more dangerous than beef for food safety. I guess I'm looking for some advice of how to tie this all together. And instead of going with the status quo, how can we change it? Thank you.
Mr. Chairman, Senator, that those regulations are incredibly complex, and you're correct. All of those items are treated differently. And what I've been told, and I don't know if this gives you any solace, but the reason that you have different items that are approached regulatorily differently at the federal level is because of various international trade agreements over years that, you're trying to address some certain problem of a certain country, and it only affects chicken, but it would have a negative impact on the beef market. So you write a regulation, you try to overcome it, you try to make all these international countries be on an even playing field for international trade. And what you end up with is this landscape of bureaucratic maze that you're trying to wander through to figure out what's legal and what isn't. I wish I had a better answer for you, but as I understand it, a lot of the differentiation amongst products and regulations have to do with sanitary and phytosanitary agreements of international trade agreements in agriculture. So they're very pervasive throughout the industry about disparate agreements for different ag products. That's why you see so many different layers of everything.
Go ahead, Senator.
Once we solve that, then we'll move into fish.
Senator Love.
So this is just a comment more. And so the 1906 original document that came out there was an investigative reporter that went out and found issues in the processing industry. And then Upton Sinclair, if you want to go have a good read The Jungle by Upton Sinclair. And it describes what was going on in the food industry at the time that this original regulation was written. And it's going to seem really egregious when you read it because of the conditions that exist. But just know today that just in the last couple of years, we've shut a plant down in Texas because of similar scenarios. And know that worldwide, those conditions still exist. And that's the reason all of these international trade agreements exist. But that book will give you just a little taste of what some of our industry people are willing to do to the unsuspecting public. And when you say buyer beware, you don't know what you're getting when you order Mexico beef or Argentina beef, or a lot of times you don't know where the origin's at. We just started trying to solve the origin problem. So it's not as simple as we want to make it. And so I would encourage everybody to just go do a little historic research and find out why we started this process to begin with.
Anybody else? One more quick one, Senator McEwen.
We have the ability when we order meat to order just American beef, or they identify what country it's coming from. Funny thing is, sometimes we'll get primals from Canada and they'll have the maple leaf on the wrap. So the retailer can control it a little bit. Thank you.
Mr. Chairman, committee, thank you for your time as always.
Very good, thank you. Okay, I guess we'll open it up for public comment here, unless there's any other agencies that want to speak on this before we do that. Seeing none, Mr. Lindholm, the perch is yours.
Thank you, Mr. Chairman, members of the committee. My name is Tyler Lindholm. I'm the State Director for Americans for Prosperity, and I got a little bit of experience with this act. Mr. Chairman, members of the committee, first of all, a hat tip to the Wyoming Department of Agriculture for, first of all, trying to help wade through the complexities of food law. Food policy is crazy. It doesn't make sense. And for the most part, the federal government has absolutely screwed it up. An example that Senator McEwen kind of alluded to is the fact that I could butcher chickens right here, right now, and sell them directly to consumers without any interference from the federal government. But I can't sell a steak out of my freezer unless it's been through an inspected process designated by the federal government directly to the consumer. Now, what is the difference there, Mr. Chairman, members of the committee? Well, clearly, chicken cannot grow bacteria. It's obviously wrong. The difference is a chicken carcass is about $5. A beef carcass is worth considerably more, especially nowadays. And there's, essentially, I'm not going to go on too much of a high horse, but there's a lot of interest, especially out of a monopoly that we've propped up under the Federal Meat Inspection Act. If anybody wants to ding Theodore Roosevelt on anything, this is the thing to ding him on. Although the Federal Meat Inspection Act, originally drafted in 1906, did not have these considerations in play. And that's an important note, that did not happen until the 1968 Wholesome Meat Act, or Wholesome Food Act. That's when the wheels really fell off the bus. And that's when ranchers were essentially shut out of the industry of retailing beef wholesale, unless you've got your proper pieces of paper and your proper licenses. All that being said, Mr. Chairman, members of the committee, Americans for Prosperity, we stand ready and willing to assist in your endeavors to get this situation cleaned up. Representative Strzok made mention that the Wyoming Food Freedom Act seems like it's been bolted together, and she's absolutely correct. From the original version that was passed in 2015 to where we are now, there's a consistent chasing method that has happened in the act. Whereas the Wyoming Department of Agriculture and their inspectors do something that is deemed offensive by the Wyoming Legislature, the legislature goes in and fixes it. And here we are again. And so in this situation, I do think that the bill is well-intentioned, but I do think there are some issues that we can clean up when it comes to specifically the legislation. On page 2, I think if you look at that legislation as it's written, one of the unintended consequences would be that you would essentially force some of these entities to become commercial businesses. I can't speak for them, but to my conversations with them, that is absolutely what they don't want to do. I think if you were going to move forward with this piece of legislation, you would go to page 2, line 16, strike in a commercial food establishment. Line 18, strike in writing by the commercial food. Line 19,
Mr.
establishment.
Lindholm, I'm sorry, would you back up on that real quick so that we can
Yes.
get those marked on my sheet here?
Yes, Mr. Chairman.
Yeah, go ahead.
This would be on page 2, line 16, strike in a commercial food establishment.
Okay.
Line 18, in writing by the commercial food. Line 19, establishment. Mr. Chairman and members of the committee, that would be only if you were looking on a fix today instead of moving forward with Representative Strzok's idea of possibly doing a rewrite so you can bolt all this back together in more of a cohesive way. And I think the Wyoming Department of Agriculture agrees with that methodology. Furthermore, in the legislation, Mr. Chairman, members of the committee, the Wyoming Department of Agriculture alluded to this. Some of the language that is being amended to handle the meat situation that's happening in Representative Johnson's hometown, that would be essentially being put in place under the trigger bill that was passed in a prior year. So it would kind of make it unworkable. I think, Mr. Chairman, members of the committee, if you were to move forward with a fix in that regard, allow retail license holders, such as the ranch that was allowing this food stand in Cheyenne to act as designated agents, you would put into law under Title 35 that retail license holders could designate agents at no cost to the designated agent or the retail license holder. So that way it makes it very clear that designated agents do have a place in the retail beef market. I think that would help that situation. And Mr. Chairman, members of the committee, I did hear something out of the Wyoming Department of Agriculture that I guess I don't agree with them on. And specifically around this Hippie Cow Creamery, where they were producing frothy lattes for their consumers, right? This is a farm stand. This is not a commercial business. And the assumption under what we read from the Wyoming Department of Agriculture is that this establishment is essentially a commercial business. They are not a commercial business, nor do they want to be a commercial business, but I will let them testify to that for themselves. If you look at the Wyoming Food Freedom Act and you look at the definition of delivery, there's a portion under that definition that says, or anywhere agreed upon between the producer and the end consumer. The producer was Hippie Cow Creamery. The customers are right there in their farm stand. Now, Mr. Chairman, members of the committee, clearly there's a difference of opinion between the regulator and some random guy from Sundance, Wyoming, and that's completely fine. And I think that is the role of the Wyoming Legislature and the Ag Committee to make it very clear that they are allowed to do that. And I think you can either fix that under the definition, you can fix that with some suggested amendments that I prior mentioned on page 2. But just the same, a fix is definitely needed in this regard, and I think that would be helpful. And then also coupling in the designated agent aspect for retail licenses would be good. And I question on the retail license aspect, because when you're looking at the meat inspection process, what you're looking at is if you're going to retail beef under the current guise that we live under the Federal Meat Inspection Act, you have to go through either a state inspected or a federally inspected facility. And then at that point, you have to get licensed. So oftentimes folks in this world call it licensed and labeled, right? So you have to have that retail license. And so I heard earlier that the reason for the retail license is for traceability, but that also assumes, Mr. Chairman, members of the committee, that the inspection process does not have traceability. And if that is the case, that we do not have traceability under the inspection process, then why do we have the inspection process? And if we do have traceability under the inspection process, then why are we doing the retail license process? And so, Mr. Chairman, members of the committee, all great things to think about. Like I said, food policy is exceptionally complicated. To Senator McCowan's comment there at the very end, what about fish? We're going to get into fish next. Actually, the federal government allows states to wholly set however they want to handle fish. So you can retail under the Wyoming Food Freedom Act, you can retail farm raised fish, except for catfish, because for some reason that was cut out. You can do that completely without any inspection process whatsoever. Obviously, the catfish lobby was involved in the drafting of the the Federal Meat Inspection Act. Mr. Chairman, members of the committee, it's weird. And with that, I'll stand for any questions.
Thank you, Mr. Lindholm, and thank you. I should have introduced you as the author and prime sponsor of the Food Freedom Act for anybody online or in the audience here that didn't know that. So that was a good move you made back in 2015. So thank you for that. Go ahead, Senator McEwen.
Just one quick comment on fish. That also includes stuff caught in the ocean.
Mhm.
It's just sent to you. Thank you.
Questions from the committee? Yes, Representative Strzok.
Thank you. I think my biggest question would be, how do we get, because we don't meet for a while, and some of us may not even be here to fight for this. How do we get it so the hippie cow can sell now? What can we do now so they can start selling their lattes again?
Go ahead.
Mr. Chairman, members of the committee, I don't know if Director Miyamoto's open to leg wrestling, but I think that's about our only option, and I don't think he is. So I think in this regard, for a direct solution as it currently stands right now, so Hippie Cow Creamery could go back to their original way. I don't think they're going to allow them because they're considered a commercial food or commercial business. Their farm stand is. Mr. Chairman, members of the committee, that this goes into a super complicated area that also complicates the Food Freedom Act. And this came from Senator Dan Dockstader out of Star Valley area. There was a situation where retail food or retail products wanted to be, an entity wanted to sell retail products right next to their food freedom products, but that couldn't really be envisioned under the original Food Freedom Act. So if you look under 1149-103 small d, that's how it was envisioned. And that was in working in concert with the Wyoming Department of Agriculture on how we could actually skate on this razor by where those products could be sold side by side. And this is another good example of Hippie Cow Creamery. The breakfast items that were alluded to earlier were actually from a commercial food business license. They were not from Hippie Cow Creamery. They were acting as a designated agent to retail those products, the way I understand this issue, which is envisioned, as I said, under 1149-103. So the question is, can those products be considered, can a retail operator designate agents? And so I think if you go after those retail licenses where they can designate agents, I think in that scenario, you fix those scenarios. But also, there's probably two folks in this room that are much geekier about food policy than I am because they're paid to be. I just do this as a hobby because I'm weird.
Go ahead, Representative Strzok.
Thank you. I do know that there's some states, and I'm pretty sure it was in Arizona, they were able to continue because they brought them the milk and the coffee and they stirred it themselves. Is this something that we will allow this to happen so they can keep doing this? I mean, this is it's ridiculous. And that's all I will say here, that we have interpreted some things that they're not allowed to mix it themselves. But is this something that they could then, the people could stir their own, and so they can continue to do some of this? Is this something we've worked out?
Go ahead.
Yeah, thank you, Mr. Chairman. To Representative Strzok's question, that's to my understanding that was a suggestion that they were allowed to deliver the two products and then the customer could combine themselves. the rub in that scenario is, and I'm not a latte aficionado or an expert in this regard. I just like Folgers. That being said, I mean, they got to froth the milk, right? Isn't that a thing? You got to froth it. Yeah, that's what those little fancy cappuccino machines do. And so maybe delivering the frothed milk plus the coffee, and then you combine, maybe that would be a solution. Great question for the Wyoming Department of Agriculture, if they would be able to, under their rules and regulations, be able to stand down in that situation. Maybe that would be something Hippie Cow Creamery would be even interested in. I don't know.
Yeah, thank you, Representative Strzok. Just to add to that real quick, we'll go to Representative Johnson. When you say they wouldn't allow them to do that, who is they? Is that the county sheriff or is that the Wyoming Department of Ag?
Mr. Chairman, to your question, I actually believe it's even a little bit more complicated than that. I think there was a city inspector that was involved in that situation also, and then the Wyoming Department of Agriculture.
Thank you. Representative Johnson.
Thank you, Mr. Chairman. This is more of a statement than anything, but I look forward to working with you to lessen the regulatory burden on our citizens in this Food Freedom Act and throughout all of government. Thank you.
Oh, Mr. Chairman, if I could real quick. Mr. Chairman, members of the committee, in regards to 27 LSO 0040, the LSO stated this is essentially the REINS Act that you guys did several years ago. That also essentially is correct, right? Also proud that Americans for Prosperity also supported that piece of legislation. So I guess we're batting 100 today. But Mr. Chairman, members of the committee, I do think that would be a welcome addition if you went after all the rules as far as just lowering that bar value way down. Because, Mr. Chairman, members of the committee, there was a piece of legislation that would have handled that during session. Unfortunately, it failed to meet the threshold of the introductory vote. I believe in the Senate, it failed to, I think that's where it started out. But reducing that from 1 million down to a more manageable number, something that would be, that would affect a lot more of our small businesses, would protect them more too.
Mr. Chairman.
Thank you. Go ahead, Representative.
That is being brought up in another committee by me, so we're still on it. Thank you.
Others? No, it was good discussion. Representative Strzok, I think, yeah, maybe we can get I hate more committees, but kind of the people, Representative Strzok, McEwen, Senator Love, a lot of them and Representative Johnson with the Department of Ag and yourself included, if you want to be part of that, and try to broaden things so we're spreading the freedom a little further than it is right now, potentially. And I think it would be good, the question on how they move forward today. You know, we won't be in session for another 6 months or so. And who doesn't force that? And can they continue to operate without going to the hoosh cow? Yeah, could you comment on that, Mr. Lindholm?
Yeah, Mr. Chairman and members of the committee, I think as far as moving forward today, I would be super interested to hear what Hippie Cow Creamery, who's in the back of the room, has got to say. If they'd be open to that, and the Wyoming Department of Agriculture, if that would be acceptable for them. But in regards to the committee, I'd be happy to help. I think it's a great endeavor. You know, over years, legislation gets amended and trying to chase our tail. And so happy to help bolt things back together in more of a streamlined format that the Wyoming Department of Agriculture would feel comfortable with.
All right. Thank you, Mr. Lindholm. Anybody else? We're good. Okay. Who's next? Come on down. Yes, sir. Free the latte. I like your t-shirt. Go ahead and introduce yourself and feel comfortable. Let us know what the committee can listen to.
Good morning. Good morning, Mr. Chairman and the committee. My name is Mark Nelson. I'm one of the owners of Hippie Cow Creamery. I just would like to state that this is the first and only time I've ever testified before a committee before. So if you'll bear with my faux pas, we'll try to get through it. There's a couple of things that I I don't want to be argumentative, but I'd like to correct on the testimony of the Director Miyamoto, which I'd like to say, all of my dealings with Mr. Budd have been fantastic. I think that he clearly, in my opinion, found some of the errors in maybe the wording of the law, that it's actually a map to correct it, in my opinion. We argued specifically that Hippie Cow Creamery was the lease. We leased the property where we had our farm store. So by all legal definitions, we are the owner. We're being held responsible, et cetera, for that property. So my argument with that property now became the extension of our farm. As producers of the raw milk, that then allows us to use it. We have a kitchen at our facility, if you want to call it that. It's an espresso machine. And so that would allow us then to make our own product, use it as an ingredient. But the problem with doing that the Department of Ag pointed out is that we're actually we have to also make the coffee, and then we have to heat the milk. Now, I've been told clearly our private home kitchen was 300 yards away. I could take your order, drive down there, make you a latte in our private home kitchen, and bring it back and hand it to you. That's what I was told that I can do. Or I could go buy pasteurized milk from Walmart and come back and do it that way if I got a commercial license, which, by the way, that was one of the conditions that was offered to us from the very beginning, that we would, if we got a commercial food license, we then could make lattes, not with our milk, with store-bought milk. We actually looked into that, and I think Mr. Budd would agree that it takes us out, then it therefore takes us out from the protection of the Wyoming Food Freedom Act. We were also told in the notes from their inspector, and I've been self-employed for 35, 40 years. I've had multiple employees. My employees represent my business. I'm also ultimately responsible for what my employees do. Their employee, the inspector, said that this facility may not sell inspected and licensed coffee. However, the Food Freedom Act clearly states that if it's in a separate station, if you will, and so they told the inspector was asking us, basically telling us that we had to pull this coffee off of our for sale items, even though it was a separate location. We were told to stop all sales of licensed facility product, which is that coffee. You're correct on the breakfast burritos were made by the owner of Zapata's restaurant in her commercial kitchen, made with USDA approved meat. She was told that once the package comes off the meat, even though it was made in her commercial kitchen, the USDA approval no longer applies. So this is what a small business owner owns a restaurant on Main Street, Cody, making the breakfast burritos in her commercial kitchen and bringing them to us as a designated seller is in the refrigerator on a separate shelf, that she was not allowed to do that. That was one of the violations. We actually weren't given any kind of violation at the time of inspection. It was 2.5 weeks later where the city called me, said that there had been a formal complaint filed by the state, a state representative. That state representative was the inspector. So therefore, that brought in then the building inspector and the state fire marshal. We had to sit down for an 1.5 hour long meeting with the city fire marshal and the city building inspector, talking about what our plans were for an 1.5 hour, explaining this is what we're willing to do, this is what we're going to have to do. Short answer is we're going to have to spend $20,000 to put in an ADA accessible bathroom, even though there's one literally 65 feet away that is ADA compliant. We still would have to put in an ADA bathroom in our facility. We have to have all the sinks, et cetera, et cetera, et cetera. And then at the very end of the meeting, the state health inspector said there's still no way that we could make raw milk lattes with our drink, with our product. We still would have to become a commercially licensed establishment and still have to use pasteurized milk. However, I could still go down to my house 300 yards away and make you a drink with our product and bring it back and sell it to you. That's completely legal. We have, in the meantime, we're making cold ice lattes we're actually calling them freedom lattes. And we can pre-package those, make those in our home kitchen and bring them up there and sell them. So the reasonableness is kind of seems to have gone out the window. There was a couple other things. One of the things I would point out, the initial complaint was told to us that it was anonymous by the health inspector. It wasn't anonymous. It was the woman's name is right there on her email address. She is a friend of the inspector. This is a small town, Cody, you know. The original complaint came from a friend of the inspector who didn't like one of our vendors. I should say, we also are operating as we are designated agent for over 20 vendors. They rent a booth space from us. That's the only way we're sharing the rent amongst 20 vendors. So that vendor, then we collect their money and give them directly back. We're not responsible for them stocking their product or anything, but we operate as a designated seller agent. So we were told first we would have to get a retail license in order to do that. Then we were told later we would have to get a commercial license to do that. Again, I was no expert on the Food Freedom Act. I still am not, but I had to suddenly find out what we were doing wrong and find out why. We were told to stop selling raw milk lattes. That there was no way we could do it. Again, back to the complaint. The complaint was not anonymous. It was a petty one farmer's market vendor jealous of one of our vendors filed a complaint with the health department, which then initiated this entire process. One of my comments was, if we're operating under the Food Freedom Act, then why are we suspect to inspection? Or, you know, we're not supposed to be suspect to inspection. The health inspector just showed up and spent 4 hours going through our entire process. And actually at that time didn't even say anything to us about coffee or lattes or anything. It was 2.5 weeks later that it was brought up in violation with the city. That's just one thing I'd like to clarify. I actually, again, yes, sir.
Senator McEwen wants to chime in here before we go.
I just want to make sure I understood what you said. You had a full-blown health inspection
Yes, sir.
and you don't have a food license?
Correct.
What about the Fourth Amendment? Thanks.
Correct. Thank you. I asked the same question. I don't know how that, what rights the health inspector had to come into our facility and spend 4 hours inspecting us. Every single vendor. At the time, she found, what we were told, she found 3 minor violations of labeling. We weren't even told anything about the meat at that time that had anything to do with the meat. And I'd argue again that the burritos that she did find that were in violation were made in a commercial kitchen. And that owner of that commercial kitchen is no longer allowed to sell her meat in her burritos in our facility. She's had to take that out, according to the health inspector. I give all kinds of praise to Mr. Budd. I've been dealing with him. He's been very understand. I just think he did a great job of outlining what does need to be changed. Again, a couple points I'll add is that we are the legal landholders of that property. Why is that not considered an extension of our farm then, therefore? 300 yards away from where we milk the cows. The other thing that they pointed out, and I think it's valid, is that they narrow focused in on the from a private home kitchen. So if something has to be processed or made from a private home kitchen in order to be protected by the Wyoming Food Freedom Act, then that would negate vegetables. It actually negates our milk. There's a few things in there that makes me question that if we narrow in on must be made in a private home kitchen. I'm trying to think if there's anything else that I can add. They offered a few solutions. Again, this letter I think is very good in outlining how we should go about it. In order to have our customer come in and hand them, this and that and say, go ahead and help yourself to the machine. is kind of unreasonable, don't you think? I mean, we can't even pull a shot of coffee from our espresso machine, a commercial espresso machine. We can't, and then again, frothing the milk. I would make the argument that frothing the milk 165 degrees for 15 seconds pasteurizes it. So there are a few loopholes in here. I know that having raw milk lattes across the United States is becoming kind of a hot item. People would like to be able to do that. I will also state that Wyoming is leading the nation in this. In the Food Freedom Act, everything that we hear from all the producers across the country have stated how just Wyoming is leading the nation in this. And what was your intent with the Food Freedom Act? It was to have an informed consumer to be able to make the decision for themselves. I'm an informed consumer. I'm 60 years old. I can decide what I want to eat, what I don't want to eat. And so I think it
Let the buyer beware is what you're saying.
Amen. Let the buyer beware. Yes, sir. So I don't even know quite why it's narrowed down to even, I don't understand, frankly, why it can't be sold in a drive-up coffee kiosk if there's a sign outside that says if you as an adult want to order raw milk, why can't I? That is the impression we're getting all across from our customers everywhere. It's kind of ridiculous that it's come down to these guidelines. Thank you.
Thank you, sir. Go ahead, Representative Johnson.
Thank you, Mr. Chairman. And just a question for you. If we redefined pasteurized to include the frothing process, would that help you out?
I'm sorry.
Go.
Yes. Possibly. There's again, we're part of a legal defense fund, a national legal defense fund that deals with raw dairies. And there's, just to clarify on if you're not a milk or if you're not a coffee snob like I am, I guess, there's hot lattes and there's cold lattes. And the Legal Defense Fund has recommended that you could actually froth raw milk to pasteurize it and then chill it and use it in a cold drink. However, there's still a problem with we can't even, by this definition, draw a shot of coffee from that. So it's a little bit more than just the definition of the raw milk being pasteurized or not. I believe it has everything to do with where it's made. Where?
Thank you, Mr. Chairman. Let's talk about regulatory burden. How much does this latte cost you?
Prior to I would say in our ignorant state where we understood that there was nothing we were doing wrong, so we could just go ahead and make lattes, we were doing that. And it equated to the sales equated to more than our rent payment on our facility. So as a small business, that's fairly significant. Then you add into the fact that we're desperately, just a quick history. This business started for my daughters and my wife, and the ability for my daughters to be able to stay home. My oldest daughter, Sadie, back here has 6 children. And instead of putting her kids in daycare, they're down here on our farm helping milk and so on and so on. And so the idea was we've been slowly growing this, have never borrowed a dime. They've struggled, worked hard. We have 2 vats milk vats that cost us $5,000 each. We'd love to expand our facility into a bigger parlor and grow. And now we're forced to spend $20,000 on an ADA accessible bathroom because of this incident. The city knew what we were doing, and they said we fell within a gray zone, that they were willing to just let it go because there was an ADA bathroom 65 feet from our front door. Now, because this has been a spotlight, from the city's perspective, we have to put in an ADA accessible bathroom. So in order of magnitude of how this affected a small 4-person, it's myself, my wife, and my 2 daughters. There's 4 of us. I also have my own business. I'm just chief chore boy for Hippie Cow, but that's a significant amount of money. So if you factor in that we've lost income of over $1,300 per month from not being able to sell lattes. And then now we're forced to spend $20,000. That's significant. We'd much rather spend that money on improving our parlor, improving our investing in our facilities to make milking better, et cetera. So this frivolous email turned into a fairly expensive venture for Hippie Cow Creamery, not noting the time that we've spent traveling, et cetera. Thank you.
Thank you. Go ahead, Senator. Anybody else? Yeah, Representative Baumann.
Thank you, Mr. Chairman, and Mr. Nelson, thank you very much. And this too is a comment and a question. In Wyoming, we see that small businesses are such a big part of our communities and also our income. And for sales tax and different things like that, and not having government entities begin your business is a real plus in my eyes. The other thing is when you were talking about fraudulent things happening, we're seeing that more and more and more as we go on, that nefarious things are happening to spiteful, to put people out of business, and to just destroy people. And so I am sorry that that is happening to you. We are aware of those things going on in this state and are trying to take some steps towards eliminating some of those things. And the third thing I was wondering about was, were you, since you had the inspection and then later on were notified, do you see this as specific regulatory items that you should have known about, or do you see this as interpretation by the people that were there?
Go ahead.
Thank you. Yeah, I have to say that I believe that it was a overreach of a mid-level bureaucrat, meaning the inspector. And I'm trying to be very nice, but we had that meeting on Thursday with the inspector, and on Monday I had a complaint. I had a contact from the county planning and zoning director saying that there's been complaints filed about what we were doing on our farm. So suddenly we were getting hit from the county planning and zoning also. I can't state that that's a direct result of that, but I believe the health inspector, Vicki Snyder, said in our store, we frankly innocently offered her a latte. We're like, would you like a coffee? She said no, because raw milk gives her the heebie-jeebies. So we have a health inspector that clearing stately that she doesn't believe or agree with the sale of raw milk. My interpretation, I'll state this clearly, is my interpretation. If we had pursued the packet of getting licensed as she originally wanted, I don't think it would have proceeded any farther. We then said that we were not going to get the licensing because it took us out of the protection of the Food Freedom Act. She denied that in the meeting with the city, said, no, it doesn't. And I have city officials sitting there that would state that that's what she said. She told us if we got the license, we would be fine to continue selling under the Food Freedom Act. Frankly, I reached out to Tyler, and that's how we tried to interpret and understand the Food Freedom Act. Thank you.
Committee. Mr. Nelson, appreciate you being here. I mean, what you're going through, I admire your calm demeanor for the boot that was just put on your neck from, as you put it, overreaching Big Brother effectively. And, you know, that's why lattes are going to be $25 a cup instead of $5, is because of that. And it's just going to run all these small businesses, you know, into the cave. I mean, you have no choice. So I applaud you for sticking up for what's right here and not just, you know, rolling over on this thing. I think it's something, I'm glad it came to light here, and we can hopefully help you with, you know, with the laws to broaden and free the latte. So thank you for being here today. Mr. Miyamoto, do you have a second? Senator McEwen, I think, has a question for you, if you don't mind.
Thank you for coming back. It's sort of a hypothetical question. If I slaughtered a cow in my garage and butchered it there or cut it up, could I take it to a farmer's market and sell it without an inspection?
Mr. Chairman, Senator McEwen, no. You could use it for your own personal use. You could, you and your family and non-paying guests could use it yourselves, but yeah, you have to, anything that's offered for sale has to go through that inspection process.
Thank you for the clarification.
Thank you, Mr. Miyamoto. Yeah, oh, yeah. Don't leave yet. Representative Struck.
Thank you. I'm not sure how to phrase this. I think when the government overreaches like they really just did, we are working so hard in this state. I hear all the time, small business, keep people here, keep people in Wyoming. This is a way that we're making people leave Wyoming. When we have these kind of regulatory overreach, is there any way that they could have some compensation from the state? What do we have that we could help anyone that does this? And I was on the Ag Initiative. How do we keep ranchers going? How do you keep farmers going in this state? They really just wanted to throw money after sitting through that at colleges. That's what I saw in it. We do not care a lot of it. We don't seem to really care about the people. What we say we do. But what is this? How do we compensate people that are sitting there trying to make a living? And we've hurt them. We've hurt their family. I have the same kind of situation that they're talking about. My daughter, we have done this. We're selling this milk. She's able to stay home with her kids, homeschool, because you work, well, it's more than just twice a day, but in a sense, then the kids are out there with us. Same deal. I'm just really upset how we can just go, oh, well, we're going to fix it. We'll fix it later. We're going to work on this. But we've set them up. We've set people up, actually, in a sense. And we've taken and we've picked this apart to the point we interpreted it so it actually hurt them. And anyone could come interpret it different ways. And I'm just really bothered that we just are like, well, that's what, $40,000. Oh, well, they'll make it. What if they didn't make it? Now you've heard it. We've, as a state, that we say we care about people, that we just, I'm not seeing that. I'm not seeing that we actually care about our people. Thank you. And it wasn't even a question, but is there some way, what is there, some compensation for them?
Well, Mr. Chairman, Representative, not sure quite how to respond to that. I think, generally speaking, when it comes to our inspectors, we've had a lot of conversations about this, and obviously we get a lot of complaint anytime any of our inspectors take action with anything. And so I would tell you, looking at our case notes on all of these things, I would just say that our inspector would characterize these interactions differently than what we've seen. From their perspective, they've got this obligation where they know they're going to get criticized if they do anything. When it comes to the Food Freedom Act, if you read in those purposes, we went through there and tried to figure out, what is the path forward? Is there a way to do this? And unfortunately, we have this distinction between homemade and commercial. And so if you want to sell under the Food Freedom Act, the purpose of the act was to make those items available for people. But if it's your intent to open a commercial business, it's a different set of rules. And we've got inspectors that are trying to to follow those statutory obligations that they got. Again, I can't blame our inspectors when they know that if they don't interpret that statute correctly or they fail to act, that they're going to be liable if something happens. And so that's really the standpoint by which they're taking a look at all of these statutes. And we have had interactions with attorneys on how should we interpret this statute? What does homemade mean? What does home kitchen mean? You know, all of these things are questions that we ask ourselves so that we can come forward with a neutral interpretation. If there really is regulatory overreach and statutory misinterpretation, I can promise you we'll get a lawsuit out of that. I don't know how else to respond to, you know, the question other than to say, how do we help the citizens of Wyoming? That division is called the Consumer Health Services Division, and it's a consumer protection service, you know, and so what is their job? Their job is to go out and make sure that there's a level playing field between businesses and that everybody has an equal opportunity to meet the same standard in order to compete in commerce, and then to protect the consumer. That's the design of it. And again, won't argue the merits of the specifics of that, but that's the design of it. So, you know, I guess it's a matter of perspective, but I can tell you with great confidence that, you know, when it comes to our inspectors that find themselves in these scenarios, they would rather not. They would rather not do these things. So it's something that it's my expectation that if it's in the statute, then that's what we do. Because our only other alternative is, well, let's just ignore that statute exists and we'll just not deal with it. That's not a reasonable response for me. That's you guys have an expectation when you pass a statute that we're going to implement that. We're trying to do that as sterilely as we can with these regulations that we come out with, and I feel confident that we can defend the decisions that we make, but they're still not going to be agreeable to everybody. All right. But yeah, I don't have anything better than, you know, how do we help? We try to implement those statutes as fairly and as sterilely as we can. And we try to do that without regulatory overreach, and we try to do that without misinterpretation. We talk about these scenarios a lot.
Senator McEwen.
Thank you, Mr. Chairman. I can understand everybody's frustration, and I believe most of it's federally driven, the overreach. To give you an example, a jar of pickles. I sell pickles, and they're pickled in vinegar. And most people that do their own pickles keep them for years and years, yet mine come in with an expiration date. Oatmeal, expiration date, stuff of that nature, canned foods. And I tried to reach back to figure out what standards they used to put these dates on them. And it's kind of nebulous. Nobody could really answer why pickled beets are only good for 90 days and corn's good for 70 days and green beans are good for 45 days. And I'm just picking numbers out, but it does vary. It seems like we're trying to come up with this nutrition cube that everybody has to eat, and it'll be delivered by the government, and there'll be no choices eventually. And I just want to bring that up, and I think that's the frustration we're having with this committee. Thank you, sir.
Anybody else?
Mr. Chairman, Senator,
Yeah, go ahead.
empathize.
Pardon me?
No further comment other than to say, Understood. Yeah, it's oftentimes very challenging for us to distinguish too amongst all these various regulations and requirements for implementation and about, how are we going to walk this path? How are we going to tightrope this thing to try to make it as fair as we can? But yeah, at the end of the day, we're trying to do that without bias. That's the goal.
Well, thank you, Mr. Miyamoto. I'll just add one thing. I haven't been in the legislature long, but I've spent a lot of time in sidebar meetings, whether it's this one right now that wasn't even on the agenda, or last time it was the meat processors, as you recall. And it's the small businesses that are just getting thumped over the head all of the time. And, your leadership is critical. You're at the top of the food chain, no pun intended. And common sense. I've had to deal with building inspectors my entire life, and some come, some go, some are good, some are not so good. But the ones that have common sense that aren't necessarily, complying with the letter of the law, it doesn't make any sense that he has to spend $20,000 for an ADA bathroom when there's one 65 feet away. So anyway, your leadership is important, and help out these small businesses. Thank you. Yes, we got another one from the gallery here. Sir, go ahead and state your name and tell us who you are and where you're from.
Thank you, Mr. Chairman. I am Brad Tyndall. I am president of Central Wyoming College and also a founding member of the Wyoming Food Coalition. And with me online is two people, not six, and my apologies to our good LSO folks. Katie Talbot for too much exuberance and confusion in Zoom land. But I would like to make a few comments and possibly pass it over to my team. But first of all, I want to really laud and appreciate you all for really spending the time and digging through the frustration of this, because this matters. We have plenty of data to show this, but we are making good strides because of this work. I understand there's frustrations for the Department of Ag, and Mr. Miyamoto is doing the best he can. I think keep pushing on this and kind of playing offense is important. It is worth the time of this committee to meet because it's quite substantial. And there's a whole lot of people in this Wyoming Food Coalition membership and space whose hero is Tyler Lindholm and folks like Mr. Nelson with Hippie Cow. And that's our organization who they represent. And we do provide consultancy services to help people navigate this space. And so we kind of live in this very frustrating space, and that's kind of our job in a way. But I do want to just highlight that it is worth it because there is a lot of growth. It's not just a minor, yes, I love that this is about food freedom. Super proponent of this. This is why we exist. But also it has serious economic impact. It's not curiosity, and it impacts a lot of individuals, but there's data to show that this is growing exponentially in the state. We have a lot of pride. When we say, we're a leader in the state, sometimes those are just words, but the data to show it is we have grown now within Fremont County, for example, 2 local food stores that only sell local food in Fremont County alone and across the state. I hear a variety of numbers that we can get the numbers for you, but somewhere between like 30 and 50 local stores only selling local food. And how you count that's a little tricky, I imagine, because whether it's a food stand or not, but it's quite impressive and it's worth the fight. And let me just say that as putting on the head of the president of the college, we have invested so much in this, and this legislation is critical. We have, yes, as Representative Ottman mentioned, we had multiple, USDA approved mobile slaughter unit. We have a USDA physical space for slaughter training and for production purposes. We have an incubator farm. And these are all investments. So up in Sinks Canyon, we teach small scale farmers how to, not only produce, but to sell and to market. going back to the Wyoming Food Coalition, one of our partners, Eat Wyoming, now has it so that you can order online, delivered to your home or local food market, produced in Wyoming food. And this has been a whole lot of work in terms of infrastructure, trucks, cold storage, and there's a whole lot of us in this space that are pushing hard on this. And my request to you all is to continue to play offense on this and take the time and to suffer the headaches that we all do, because this is important. And there's more. I could go on and on about the efforts across the state, the Wyoming Innovation Partnership. We have a Bootstrap Collaborative Entrepreneurship Development enterprise on our campus, which is to help small businesses grow. And you see them across the state. I think many of us are kind of waiting in the wings, watching online and saying, will you take action? I know it's frustrating. We're navigating a very complex space, but I just want to thank you and encourage you to continue. And if you have any questions for me or my staff, we'd be glad to answer them.
Thank you, sir. Committee, questions? Thank you for your testimony. Appreciate it.
Mr. Chairman,
Yes.
would it be all right if our BJ Edwards from online be able to?
Yeah, we'll
ask
go
a
to
comment?
online
Thank you.
here next, I guess.
Thank you.
Let me just check with the committee here. Do we want to take a break, or should we probably ought to go to online? And maybe, how many people do we have online? Do you know? 4? Yeah, let's just go ahead and get them done. We'll take a break. Yeah. Okay. Anybody else in the gallery? Yes, sir. Come on down. Got 2 more. Go ahead.
Thank you, Mr. Chairman, members of the committee. I came here as a support for the Nelsons. Hippie Cow Creamery. Didn't have any intention to say anything, but I just want to introduce myself. I'm AJ Richards, originally from St. George, Utah. Moved here in 2022 with the ownership that took over Wyoming Legacy Meats, USDA Slaughterhouse in Cody, Wyoming. My company, I'm no longer there. It was part of research and development I'm doing for what my company is. We connect farmers and ranchers directly with customers across the nation to cut out as many of the middlemen as possible to make sure they get the full retail dollar so they can stay in operation. That work has led me to be involved in policy, because what good's a platform if you're not allowed to sell the food you're growing in the state or town or county you're in? And subsequently, I've now been invited to work in Washington with the Secretary of Agriculture on different policies. I'm a nobody. I'm not a lobbyist. I'm not a legislator. I'm just a concerned citizen that we build the food freedom throughout our nation. And one thing I love about Wyoming, because of Tyler, is this food freedom law, because we see these challenges in different states across the nation. So my only comment I wanted to make was in regards to what Hippie Cow is providing for the community up there. They have 20 people that are offering their products as designated agents within their facility. So for the same reason that Hippie Cow and their family got started, so the mothers could stay home and rear their children, that's 20 other opportunities for other mothers within the community to develop the same opportunity. And when our country has the lowest cattle numbers in U.S. history with the 2026 population numbers, and we're losing farmers and ranchers at a rapid pace, we also have the fastest growing movement in recent history getting back into agriculture, and that's the homestead movement. But what I've seen in my work with the people we work with across the nation is it starts by looking like a small booth in a farmer's market, and then they grow. And what's happening is we have an opportunity. God's shown mercy on our nation because we have an opportunity since COVID to bring back the producer numbers in our nation, because there's an interest. People have become reconnected with the value of their food. But when federal and policies and state policies prevent the growth of that, we're shooting ourselves in the foot. We've got to open up these opportunities for these small families to get going. Once they get that momentum, they scale, and then they reinvest, and they move into a state's inspected facility level or even a USDA inspected facility. I've seen it across the country. But it has to start at the foundation, and the more bureaucracy that's in the way for them to do that, the less likely we are to rebuild our domestic food system and provide the stability for our nation. So I appreciate you letting me share that with you. I appreciate hearing this committee is so committed to our food freedom and our independence in our state. Makes me proud to be a new Wyomingite, because where I came from, the battles were much bigger. And so thank you. Thanks for letting me share that.
Thank you, sir. Thank you for your testimony. Questions for? Thank you for being here. Go ahead.
Thank you, Senator. Members of the committee, Karen Clark with the Wyoming Farm Bureau Federation, proudly representing Wyoming farmers and ranchers who support the Wyoming Food Freedom Act, the sale of raw milk, all of the conversations about sale of interstate or sale of meats, state inspected meat interstate. There have been a lot of conversations today on what needs to be done and ideas to make this law stronger for the farmers and ranchers, for the producers of the food, and the end user of the consumer. And so I sit here today offering the support. The committee mentioned potential committee work to bring forward and look at all of the different nuances that have been brought forth. Mr. Lindholm talked about some of those. The Department of Ag did. You've heard them from the farmers here today. And so the Wyoming Farm Bureau Federation stands willing to assist as a stakeholder in moving forward in this effort. Thank you, Mr. Chairman.
Thank you, Ms. Clark. Questions for Ms. Clark? Yeah, go ahead, Representative Ottman.
Thank you, Mr. Chairman. Ms. Clark, always, it's good to see you. I was just wondering, have your members voiced any concerns about pushback for their industries or regulatory things that could possibly be changed to make things easier?
Mr. Chairman, Representative Ottman, thank you for that question. Recently, not any specifics. So I don't have any specific examples for you, but when it comes to the regulations and taking a look at all the topics here, raw milk for sure, support the sale of raw milk. And then also though, when it comes to meat, that has been a very big conversation among our members, and being able to sell state inspected meat across state lines interstate would be the two top that we've been hearing from.
Thank you. Is that good? Okay, thank you. Representative Ottman. Any others? Committee. Thank you, Ms. Clark.
Thank you.
Go ahead, Mr. McGagnon.
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockholders Association. Certainly our thoughts are with the people. We need to be able to do what we want to do in Wyoming with our food products. The dilemma that we face, I think, and it really puts a burden on the Department of Agriculture, one of our highest priorities as Wyoming stockholders has been to get changes at the federal level so that we could have interstate shipment of state inspected meat. In order for that to happen, one of the key talking points that we've used that has been very valid is that the state inspection, and this is meat, but it applies in other areas as well, is equal to at least the federal inspection. So the dilemma I see is we want to do some things to lessen the burden on our people selling locally through our rules, but in doing so, are we weakening our arguments for getting action at the federal level to allow interstate shipment of state inspected meat? And it's a fine line we have to walk there. It certainly pains me to, and it's natural. If you have a problem, you can't do what you want to do, you blame the regulator. In this case, the Department of Agriculture. The reality is, and I would speak in defense of the Department of Agriculture, the reality is the regulations that they're required to enforce. And I think we certainly would be very supportive of looking at the state level. How do we lessen those regulations? But in doing so, still being at least attuned to how do we do that in a way that doesn't diminish our ability to get the freedom we want to sell our products beyond the state of Wyoming. Because certainly in the case of beef, which is the major agricultural product in this state, we can't eat all that we produce. We've got to be selling it elsewhere, and we would prefer to be selling far more of it as Wyoming beef processed in Wyoming to be sold in other states than we are just to be shipping it off to the large processors to be sold as an unlabeled product across the nation or in export. So I think we need to move forward on the policy or on the legislative front, saying what further steps can we take and yet still not jeopardize our ability to sell our products in Wyoming because we can't sell them all here. With that, Mr. Chairman, I'd be happy to take any questions.
Thank you, Mr. McGagnon. Representative Botman.
Thank you, Mr. Chairman, Mr. McGagna. Just kind of a vague question, but am I hearing that country of origin and labeling and the limited amount of processors are a problem here? And if so, is it something that we can work on statewide?
Go ahead, sir.
Mr. Chairman and Representative Ottman, not sure I fully understand your question. I don't think, as we see it, country of origin isn't the problem. It's the ability that we want to be more specific. Wyoming beef, to be able to label our product here. We run into some problems that can actually impact us negatively if we go too far with country of origin labeling. For example, our beef trade and movement of animals with Canada is critical to the success of our operation. We certainly have producers in states like Montana that summer their cattle partially in Canada and it works back and forth. So we need to be cautious with that. But what we're seeking is not a mandate as to how the product is labeled, but the ability to label the product for those who choose to do so voluntarily and want to market their product based on that labeling.
Thank you, Mr. McGagnon. Anybody else? Thank you both for your testimony. Oh, Senator McEwen, don't leave yet.
On the topic of country of origin labeling or the COOL program, there's a big pushback from the big slaughterhouses on that because it creates a lot more work to keep everything separate. But I find it ironic that I'm required to put country of origin labels on produce. So just a thought.
Want to comment on that, sir?
For the benefit of the committee and Senator McEwen, I would just point out that our member policy, established policy in Wyoming Stockgrowers Association is we are not advocates for government mandated country of origin labeling. We are advocates for the industry adopting country of origin labeling.
Thank you. Go ahead, Ms. Clark. Did you want to add to that? Okay. Thank you both very much. Okay, anybody else in the audience here who wants to testify on food freedom? Seeing none, I guess we go right online. Who's first? Go ahead and state your name and where you're from.
Mr. Chairman, I have Sadie Clarendon.
Go ahead, Sadie.
Hello, my name is Sadie Clarendon. Thank you, Chairman. Thank you, committee members. My name is Sadie Clarendon. I'm the Communications Director for the Wyoming Food Coalition, and I wanted to offer somewhat of a solution. The Wyoming Food Coalition realizes that local foods and local businesses are very critical, as well as the Wyoming Food Freedom Act, to this state, and we are a leader in progressive cottage laws. And I'm speaking today to raise awareness of the Wyoming Food Coalition, whose work has been to help draft, educate, mediate, and interpret the Wyoming Food Freedom Act for local businesses and local food producers. We have a good working relationship with the Wyoming Department of Agriculture, and I know that the Wyoming Department of Agriculture, like Mr. Joe Budd said, the Wyoming Food Freedom Act has had many, many amendments in the last few years and is very difficult to interpret. I think his words were clear as mud. And the Wyoming Department of Agriculture has to deal with the liability of facing the burden of not reporting certain questions, or if something of concern comes up, they have to report those things, right? The Wyoming Food Coalition can act as an intermediary here, and we're doing this work for free for anonymous interpretation of the Wyoming Food Freedom Act. So I did want to bring that up as a potential solution to some of these issues with liability and litigation. Thank you.
Thank you, ma'am. Committee, any questions? Thank you for your testimony. Go ahead with the next one.
BJ Edwards.
Yeah, go ahead, Mr. Edwards. or Miss
Sorry,
Edwards?
I'm a Mrs.
Go ahead.
Edwards, but no worries there. Can you all hear me okay?
Yes, we can hear you fine.
Awesome. Thank you so much. Good morning, Mr. Chairman and committee. My name is BJ Edwards, and I own and operate a small scale farm to consumer operation called Taste of the Wind. I was one of the ranches that had my frozen USDA inspected lamb product locked in the cooler at Y Fresh in Cheyenne in one of the incidences we've been discussing today. But I'm also the executive director for the Wyoming Food Coalition and proud to be. I wanted to reiterate a little bit of what Sadie said. Our Food Freedom Act is extremely critical to our state, and we've seen much success and momentum gained in the local food sales space. So we'd like to be a part of that process of bettering this Food Freedom Act so that we can leverage our existing trust from producers and our existing good relationship with the Department of Agriculture and Consumer Health to make sure that this law better serves our small businesses, our agriculture industry, and consumers across the state. I'd also like to raise awareness of the resources we have available on our website, which is www.wyomingfoodcoalition.org. So that's wyfoodcoalition.org. I think the committee may find that the resources we have, particularly around the Food Freedom Act on our website, will help increase awareness and help answer some of the questions that have been raised during this session. So I'd like to point you in that direction and also offer to help if there's any way we can help, because we are doing that work across the state currently. But I'd like to if we can, ask to be a part of that process going forward, because we do have a very much producer-based board, and we do have the trust of upwards of 428 operations across the state who are currently operating under the Food Freedom Act and marketing their products in food freedom storefronts like Hippie Cow Creamery and Y Fresh. So I think that's all I have to say, but thank you very much for your time, and I will stand for questions.
Committee, go ahead, Representative Johnson. Got a question?
Thank you, Mr. Chairman. Ms. Edwards, can you tell us what led to the I'm just going to say fiasco at Y Fresh, where you had to stand in front of the locker and sell your beef? You had to be there, and you could not have Y Fresh as an agent. I just don't understand how that got into that point. Can you just give us a scenario how that happened?
I can give you a little background, but I also I'm pretty sure that Tommy with Y Fresh is present over Zoom. So if she's able to speak, I would defer to her because she's the store owner. But as a vendor in that store, my understanding is that the health inspector was saying a similar thing to what we discussed with Hippie Cow, that they did not have the proper licensing to sell meat products. So they did offer that we as producers could stand in front of the coolers and sell our product direct. But I'm a mother of two small boys, and I was also in the middle of lambing season during that time. So that's why I had my meat in the store, was they were acting as my designated agent, and my meat was fully inspected. So I didn't see any health risk, but I also respect that there are requirements to maintaining safety requirements of a storefront. So it's a little, it's clear as mud, as we've all experienced today, but I haven't been able to sell my meat there since. So it has made a big impact on my business, because Y Fresh was my most successful storefront that I'm working with in the state. So I've lost a lot of business, and that was around Easter when that happened, which is my highest point of lamb sales in the year, every year. So I was disappointed as a producer, but I understand that we have to work towards a solution that's going to preserve food safety and also allow local businesses to function in our state.
Well, thank you, Ms. Edwards, and we'll keep that in mind as far as your offer to be a part of perfecting on the Wyoming Food Freedom Act. So thank you for your testimony today.
Thank you so
Go ahead
very
and
much.
bring it. Yes.
Mr. Chairman, if you'll ask those on Zoom to raise their hand if they'd like to speak, I would appreciate that. But also next we have Tommy Nisley.
Go ahead, Tommy Nisley.
Thank you, Chair and Committee, for inviting me here to share my story. And I had some talking points that was a little more organized, but listening to everybody, I got more. So it's going to be a little scattered here. But I did want to draw your attention to the whole designated agency, the way I understand the Wyoming Food Freedom Law and the statutes is that, like BJ, she doesn't need a meat license because she is the direct seller. It has to be USDA. So it is already regulated to make sure it's for safety. But like she doesn't have her freezers and stuff inspected. And we believe we were acting as a designated agent, and designated agencies are completely implied, just like the director of Miyamoto is acting as a designated agent speaking for the state of Wyoming. We do not buy meat and resell it. It's clearly labeled which farm it comes from, that it is USDA certified, and it is, the money is diverted at the point of sale directly to our farmers. I would like to challenge some of the ways the inspectors go about doing this. We're not asking the Wyoming Department of Agriculture to ignore anything, but we can interpret the Wyoming laws differently. And when we were presented with the Wyoming Department of Agriculture, when they come in onto private property and detain private property without a due process, I'd like more of a due process. I respectfully asked, how do I make an appeal? At which the inspector got upset about and said she didn't know and referred me to the Attorney General. The Attorney General said, we don't give advice to our citizens. So we consulted with an attorney friend, and they helped us put in an appeal. Our appeal was rejected, and we were not told why it was rejected. These are all glaring problems with this process that really needs to be more transparent and have a process of, hey, we're not calling you guys bad guys, but we definitely have some different interpretations of the law without putting an undue financial burden for a lawsuit. I don't think that's needed. I think we can all be on the same side. I think Wyoming is leading in food freedom, and I think we can continue to do it. And I'm excited to be part of that process. Just looking at some of these things. Interesting thing, as it was told about safety, like to go ahead and read Upton Sinclair's The Jungle. Yeah, I suggest you read it. However, it is widely claimed now that it's a work of fiction as far as the meat processing parts. It was more accurate on the exploitation of immigrant workers. And the irony is, as of now, we still have exploitation of immigration workers in our meat processing units. So an example of this is, so meat, if you're going to sell meat by the cuts, it needs to have a USDA stamp or be state inspected. I've been told that for meat processors to be state inspected, it is the same requirements to be USDA inspected. So as a business perspective, they usually go for the USDA inspection because then they can send meat across state lines. It becomes interstate commerce ready. As far as and I'm wondering, I think that's a worthy idea to look at getting Wyoming state inspected meat across the state lines. However, it doesn't address my issue because this is meat that is raised in Wyoming, processed under Wyoming, under the USDA regulations, and sold in Wyoming. So I don't see why the federal government should have any oversight over Wyoming food. It's not entering into interstate commerce. So do we even need the USDA stamp? I would argue that, which we haven't done, but I would even argue that we should be able to sell, farmers should be able to sell cuts of meat from custom processing. We personally know 2 custom processors here in Laramie County. They're family owned. They run clean facilities. And I know there's a huge USDA inspected meat processing facility in South Dakota that there's 47 different languages spoken at that meat processor plant. And not only that, you have thousands of cattle and bison and other animals coming through it at a day, whereas these other ones, you know, it's 2 to 5. My farmers and ranchers sometimes worry about trying a different meat processor that are they even going to get the animal that they worked so hard to finish, get that animal back to them, or if it's going to be something else. Well, it's just more likely to get your animal back when you're dealing with a smaller processing plant. And I'd argue it's probably cleaner, just statistically speaking. You're less likely to contaminate a lot of beef carcasses. If one beef carcass comes in dirty and you've got thousands of beef carcasses that you're processing versus 2, I mean, just the scale, I think you'd be able to keep a cleaner product, which is about safety. Why I was told I couldn't be a designated agent is because it wasn't explicitly stated under the Food Freedom Act. I don't know if it needs to be. However, one of my farmers was told he could sell pork at my farm stand and he could bring it there, sell it out of a cooler, and then take it back in a cooler, transport it home. Well, I have a commercial 3-door freezer. If it's about safety, wouldn't it be about not keeping it in coolers and transporting it, or being at a farmer's market sitting in a cooler on a hot pavement? I mean, some of these things I think are a little asinine to try to process. I'd also like to look at the idea of weaponizing bureaucracy. I feel like that happened with Hippie Cow Creamery. I've talked to an individual in Wheatland where it was another complaint from a different vendor about another person making tamales. And then, I mean, the WDA was weaponized against us from a meeting with the city, and the official complaint came from the county health department.
Miss Nicely, I'm sorry to interrupt you here, but in the essence of time and others online and other business, I don't want to shorten you. I'd love to listen to you, all of what you have, and if you can get through it, I'd really appreciate it. Thank you.
Okay. And then I'll just close up then. I would really like to encourage you guys to continue this fight. As you all know, and I'll just give you some quick stats. As of now, they say when you go to the grocery store, grocery store, for every dollar you spend, the farmer only gets 8 cents to the dollar. We definitely have an issue with retaining our farmers. Convenience food is what sells. Over 75% of consumers' diet is convenience food. So we really need to make it accessible and lower the bureaucratic burden and regulatory burden to allow our farmers access to that convenience food and allow them access to directly to the consumer. Again, like BJ suggested, when this came out, it was during calving season, kidding season, and lambing season. It really hit my farmers hard, and hit our farm hard too. I appreciate this opportunity to talk, and I'll stand for questions.
Thank you very much, ma'am. And you made a lot of good points there. It's good getting your testimony firsthand. Committee, any questions? Thank you for being here, and we'll probably continue. Oh, Representative Ottman, go ahead.
Thank you, Mr. Chairman. I just wanted to say that I do appreciate Ms. Nisley and Ms. Edwards and all of their testimony, just to show that we need to, and we are beginning to have the conversations about access to answers to problems rather than suggesting litigation at every point. So thank you for that. Please do not stop that that conversation, because things can be worked out between the departments and legislation. And so we need to continue in that venue. So thank you very much.
Okay.
Era now.
Go ahead, ma'am.
Good morning, Chairman Ide and members of the committee. Era Arano on behalf of Rocky Mountain Farmers Union. Rocky Mountain Farmers Union's member-driven policy does support efforts to expand the Wyoming Food Freedom Act, and additionally any other ways that we can increase the ability for our producers to market their commodities and value-added products to consumers directly and through agents. We've heard several themes throughout this extended discussion today, that we are the leader in food freedom for the nation, that food freedom is good for Wyoming and for our people, and that this act that many rely on is indeed clear as mud. I'm no expert in food policy, and when I get the questions, which I often do, I refer folks directly to either the department or the Food Coalition, who've been wonderful resources. While Rocky Mountain Farmers Union would love expansion, we don't think that this bill is the right tool to do so. First, we think we need more education and clarity, education about and clarity within the act, rather than adding additional complications and rulemaking at this time. And those are things we think this bill would bring. Rather than the piecemeal exemptions that could increase complexity, we encourage the committee to do as what Representative Strzok suggested, undertake a broader stakeholder process. In addition to working out some of the kinks to the act that have come with time, the committee could identify whether Wyoming should create a separate commercial farm to commercial operators network, pilot programs, producer certification options, or other things that can expand market access. And do this all taking some time so we don't unintentionally impede the protections that have made the Food Freedom Act successful for us thus far. So we ask the committee not to move this particular draft forward, but to continue to explore the process. Thank you.
Aaron Bell. Committee, questions for her? Seeing none, thank you for your testimony today.
Thank you very much.
Anybody else online?
David Nisley.
Okay, Mr. Knightley, floor is yours.
Can you hear me?
Yes. Can't see you though.
Can you see me now? David Nicely, Y-Fresh. Just quickly, in terms of the meat at Y-Fresh, the Department of Agriculture informed us that under 35.7.124A of the state statute, agricultural producers are exempt from licensing if they're selling raw agricultural products. They determined then that because designated agency is not specified in that section, that we couldn't act as the agent of the producer and sell it on behalf of the producer because it's not specifically in the statute. The ridiculous thing about that is that there were agents of the state of Wyoming acting for the state of Wyoming, because the state of Wyoming can't act for itself. It doesn't have a voice to speak. It has to speak through agency. So agency is in the law. The ridiculous thing is that Tom Reed, representing his company, Reed Livestock, a corporation, can act as the agent and stand by our freezer and sell the meat. But we can't act as the agent of that corporation because the Department of Agriculture determined that we can't. As my wife said, it's ridiculous that they can show up, impound our meat without any due process, that they don't even know how we could make an appeal. It's ridiculous to me that in Wyoming, the Department of Agriculture of the state of Wyoming will push back against small farmers, ranchers, and food producers, but won't push back against the federal government. And we've heard a great deal about the federal government today. Most of the jurisdiction that the federal government claims over food in Wyoming is based upon a 1942 Supreme Court decision where a farmer was growing grain on his farm and feeding it to chickens on his own farm. The feds said you can't do that under some depression law limiting grain growth. He said there is no interstate commerce. There's not even any inter-farm commerce. And the federal government, through the Supreme Court, said because he was growing grain on his farm that he would have otherwise had to buy on the market, he was indirectly affecting interstate commerce. By that rule, then, anything that happens, a butterfly flapping its wings in the Pacific, is affecting interstate commerce. The federal government claims jurisdiction over everything. It's time for the Department of Agriculture, the state of Wyoming, to say, enough's enough. This is not interstate commerce. Go kick rocks. So I'm respectfully asking that the Department of Agriculture be kinder, gentler, enforce the statutes, but don't push back against us. We're not the villains. And then with respect to Upton Sinclair and the jungle, at least one answer to the problem of the jungle is to buy your food from people you know. We don't even have to go to the point of caveat emptor. What about if I live in a world where I can buy food from Representative Johnson because I know him and I don't have to beware? See, that's the kind of place Hippie Cow's offering. That's the kind of place Tommy's offering at Y-Fresh, a place where you can come, trust the food because you trust the person, and then you don't have to live in a place with your caution high, your hackles up in fear. Let's be Wyoming. Let's be kind. Let's be respectful. I don't understand why the Department of Agriculture hasn't called me and asked me how we can work this out. You know, Representative Strzok asked the question, what can we do to help Hippie Cow sell lattes? What if we lived in a world where the Department of Agriculture and its inspectors didn't come and say, you can't, but rather said, what do you want to do? And then asked, how can we help you do what you want to do? I don't understand why we're even here. We could have had this conversation kindly and gently, but you know what? Frank Wallace, who his sister was the original pioneer of the food freedom, He opened up in Gillette. Before we started, we talked to him. He told us that he was no more than open than the inspectors came. And he just told them to get out and go read the law. So we haven't even gotten to that point yet. Anyway, I've talked and you've heard it all, and it's been well represented. So I'd suggest that if this goes forward, that 35.7.124A be amended to specifically allow designated agents. I'd suggest that with respect to Hippie Cow, that the language of homemade and home kitchen that's in the Food Freedom Act be amended and replaced with something like producer's kitchen, so that it's not specifically a private home, but a kitchen that's under the control of the producer. And maybe that would solve some of the problems relative to their problems and our problems. Anyway, I'll take questions if you have them.
Thank you very much for your testimony today, sir, and being here and taking the time out. Committee, any questions? It'd be good to keep in touch with you and the committee as we go forward. So thank you for being here today.
Thank you.
Online. Okay. We'll close public comment. Committee. Well, I think everybody's kind of taking a break here in and out. Let's go ahead and try to get out of here as soon as we can if you need to get up and use the restroom. But how do you want to go forward here? Representative Johnson.
I think we've got a lot of new, Mr. Chairman, we have a lot of great ideas here, and we just need to work on this and make this a good bill and give Wyoming the food freedom that they're looking forward to.
Any other comments? So Representative Johnson, basically you're saying we want to address these draft bills today and we'll try to work on them in the interim here and get with other folks and discuss this and really make a good product out of it.
Yes, Mr. Chairman, that's exactly what I wanted to do.
Okay.
Thank you.
Thank you, Representative. Okay, I guess with no directives, let's take a 5-minute break and we'll be back here to discuss our last issue on fencing. Thanks, everybody, for being here for the food freedom. Appreciate it. All right, we're back going here today. LSO's all here. We got a quorum, I hope. We're missing a few on the end down there. The next item on our agenda is the Wyoming fencing law amendments. I think that's what it reads there, or how does that read exactly? Let me go here. Get it official on the books. Livestock fencing requirements in Wyoming. And we'll start off with Savannah, the LSO. Go ahead and take us through this.
Mr. Chairman, members of the committee, Savannah Collins, staff attorney with LSO. I am presenting the white paper in your packet on fencing laws in the state of Wyoming. This white paper provides an overview of the fence statutes in Wyoming, the fence out requirement, and the history of fencing in Wyoming. This memorandum was drafted at the chairman's request. To begin, we will talk about who is a fence owner. The owner of a fence is a person who occupies, uses, enjoys, maintains, or has the charge of an enclosure. The owner of a fence is considered to be the responsible party for any action commenced under Wyoming's fence and cattle guard statutes. There are 3 types of lawful fences. The first type of lawful fence must be constructed using steel, concrete, or wooden posts and either 3 or 2 spans of barbed wire. The second type of lawful fence is a post and board fence with either 3 or 4 boards between the posts, and it's securely fastened with nails or something similar. The third type is a pole fence, which uses round poles that are no less than 2 inches in diameter, no more than 6 feet apart, and also securely fastened with nails, wires, or something similar. Wyoming statute also allows for fences to be constructed using other materials if they meet specific conditions. For the fence to be considered lawful, it must be declared as strong and well calculated to protect enclosures or be able to resist a breach by stock animals in the same manner as the 3 specific types of lawful fences just listed. A person that constructs or maintains an unlawful fence that doesn't meet these statutory requirements is liable in a civil action for all damages to animals that are the result of the unlawful wire fence and can also be charged with a misdemeanor. The owner of the unlawful fence is also required to rebuild the wire fence to meet the lawful fence standards within 30 days of conviction, and if they do not rebuild, then they are guilty of a separate offense. Wyoming statute prohibits any person willfully or negligently leaving open, breaking down, or destroying any bars or gates that are for the use of the public or any manner of destruction of a lawful fence. A person found to have done so can be charged with a misdemeanor. Regarding the topic of fence out, any person who owns or has in their possession livestock or domesticated buffalo that breaches into the lawful enclosure of another person is liable to the injured party for all damages that occurred as a result of the breach. Damages resulting from the breach may be recovered through a civil action or arbitration. Where there is a breach of the lawful enclosure of another person by livestock, the person who suffers the injury is required to notify the person who owns the livestock of the damage and the probable amount of the damage. If the injured person who knows who the livestock belongs to, and if the owner of the livestock resides in the county where the damage occurred. An injured person may keep as many of the animals that caused the damage in custody as equals the value of the damages that occurred. If a civil action is commenced for the damage and proceeds to trial, and the damaged enclosure is determined to be a lawful fence, then the plaintiff, who is the person who has proven the damages to their fence, is awarded the costs of damage to the fence and costs of keeping any of the offending animals in custody. Turning to fencing in livestock is a common law principle coming from England. That means that it's not in statute, it's something that came over, and there are many common law principles that are not specifically in the book, but are part of common law and still completely part of the law in the United States. There are no statutes nor rules in the state of Wyoming requiring fencing in of livestock. Under fence in, the owner of livestock is generally strictly liable where the owner has not constructed a fence to keep in their livestock and would be presumed to allow their livestock to run at large. The Western United States was mostly established on the principle of open range grazing and generally does not follow the common law principle of fencing in. In Wyoming in particular, the concept was never applied to cattle, so Wyoming is a fence out state when it comes to cattle. A foundational case for fence law in Wyoming, in 1902, there were these two men who were found liable for the damage their sheep did to an adjacent property owner's land when they did nothing to restrain their sheep from grazing on the adjacent property owner's land. The two men were grazing their sheep on checkerboard public land and repeatedly allowing their sheep to graze on the adjacent property owner's land despite repeated notices to stop letting their sheep graze there. The Wyoming Supreme Court found the men liable for the damages for a number of reasons, including that they had not honestly and prudently endeavored to confine their sheep to the public lands. Through a combination of the common law principle, the way Wyoming was established, and early cases like this one, Wyoming does not have any statutes on the books regarding fencing in of livestock. I will stand for any questions.
Thank you very much, Ms. Collins. That's a nice report you put together there. Thank you for taking that time and giving us some detail. Questions from the committee? Go ahead, Representative Straw.
Thank you, Chairman. I think my one question, I've always understood that sheep have to be fenced in. Is that how it is?
Mr. Chairman, Representative Strzok, based on research on the Wyoming statutes, the rules, and other policies of the state, there is nothing specifically on the books requiring fencing in, but it is that common law principle that we talked about that although it's not specifically written out, it's kind of the baseline law that comes into play. And I will defer to Mr. Magagna for any history on that.
Go ahead.
Thank you. So I guess the question is, it's always been a big fight. If you have cows, you have to fence them out. It's what everyone around always says. And with the sheep, you better fence them in. So how, if that is the case, because now I'm almost hearing it's not totally, it's just what we've always been told. But if it is, I would like to work on this. The sheep should be equal to these cows. We've moved past this. We should not be treated. We should not be treated as lower class citizens anymore. Anyway, I just want, so if maybe some clarification on that.
Do you want to comment?
I can just provide a little bit of rewording on fencing out, a little less legalese, a little bit more approachable. When it comes to cattle, the principle was when the state of Wyoming was founded and most of the West was founded, was that people were grazing their cows anywhere because it was open land. And when people started sectioning off land, cattle were coming on to other people's property and causing damages. And so the fence out principle comes from this idea that you keep your cattle, the person who owns the land has the responsibility to keep the cattle out. And so if people's cattle breach your fence, you've done everything you can to keep them out. That is the basis of that principle. The way that the fencing law is developed, again, I will defer to Mr. Magagna, but the concept with sheep is a little bit different than it is for cattle, and it's not as clear based on the statutory history on exactly how that developed.
Questions, committee? Senator Pearson.
Thank you, Mr. Chairman. So I as well assumed that sheep had to be either fenced in or a sheep herder with them if they were out on the range. So, and basically based on that court case that you were talking about, it was saying that those sheep producers had to fence their sheep in. So I think that kind of served as a precedent. We're going to ask Jim Magagna about all of that, but I always assume the same thing. That's the reason that many of our pastures where we have sheep has mesh wire fence, not necessarily wildlife friendly fence, but mesh wire because sheep will get out of wildlife friendly fence. So yeah, we're going to discuss this and it's going to be awesome.
Other questions?
Mr. Chairman.
Yeah, Senator
Mr. Chairman, would you,
Yes.
if I'm right here in front of you, would you mind if I could respond to Senator Pearson? Because I do think that she hit the nail on the head with the case, and I would like to address that. So although there's nothing on the books, specifically in the green books or in the rules and regulations about fencing in sheep, the case law from that 1902 case does still stand as the law of Wyoming. So the case law stands in as well. It kind of parallel with the legislative law that's written down, and that is where that principle comes from.
Thank you, Ms. Collins. Yeah, Senator McEwen.
Just curious, there seems to be some confusion about horses. I know we haven't brought that up, but are horses fence out also?
Go ahead.
Mr. Chairman, Senator McEwen, I would have to look specifically at the definition, but to point back in the memo, any person who owns or has in their possession livestock or domesticated buffalo that breaches, that is the definition of the individuals or animals who are included under that statute. And I would have to defer to Mr. McGagna on that as well. I'm sorry, Mr. McGagna.
Any other questions for Ms. Collins? Yeah, I'm glad you brought up that point on that 1902 case. There's really nothing on the books, as you said, but that case law is a precedent, I guess, that gets used, and you're liable for damages if somebody wants to take you to court, is about what it amounts to. Is that correct?
Yes, Mr. Chairman.
Thank you. Okay. We'll go from there. Is there anybody in the audience that I would assume Mr. McGagna has been put on the spot here, so we'll bring him in. Thank you, Ms. Collins. Yeah, go ahead, Senator Pearson.
Thank you, Mr. Chairman. This is just a statement to kind of introduce why this interim topic was brought. I ask that this be an interim topic to find solutions for repeated livestock trespass on privately fenced areas, since Wyoming is a fence-out state. My solutions include a criminal penalty misdemeanor, $750 or 6 months in jail, or both. For instance, after 3 documented contact attempts with the livestock owner to remove their livestock. So basically a 3-strike rule. For the most part, ranchers are pretty neighborly about managing their livestock should their cattle or bison breach a fence. But there are a few that use the old adage, it's a fence-out state, and do nothing, forcing the private property owner to manage their livestock for them, pay for fence repairs, etc. Many landowners can't afford attorneys to pursue a civil case. I would also like to see leases on federal lands be added to the fence maintenance statute. And once again, not a civil case to recover those funds, but a misdemeanor charge, $750 or 6 months for failure to help fix a fence that their livestock damaged. Also possibly a time limit for addressing the trespass. Private property owners should not have to manage someone else's livestock, be expected to repeatedly fix fences on their dime, or pursue a costly civil lawsuit to keep cattle or bison off of their property. I'm asking this committee, I'm asking Mr. McGagna, I'm asking anyone who's willing to help find a solution to this problem in the state of Wyoming. Thank you.
Thank you, Senator Pearson. And I apologize, I brought Mr. McGagna down before you got to deliver that. I should have called on that first, but all you had to do was move down a couple of rows, so you're okay. Yeah, that was a good introduction on what we're talking about here. Yeah, Representative Davis, go ahead.
Thank you, Mr. Chairman. I understand this livestock issue, but The bigger question out there is we have wild horses and we have wildlife, which do probably just as much, if not more damage to a private fence. How do we address that in this going forth here? Would be my question.
Okay. Thank you, Representative Davis. We can discuss that if any of the committees wants to chime in on that right now. They're welcome to. Or we can bring that into the discussion with Mr. Magagna and Senator Pearson. Do you want to comment on that, Senator Pearson?
I haven't personally seen a lot of issues with wild horses. I know wildlife, it is a large issue. And for some reason, I remember in years past that there was something in statute, and maybe LSO can look into this as far as wildlife. You know, and whether, I can't remember, I think that there was an agency, if there was a complaint or repeated damage on maybe like haystacks, things like that, that I don't know which agency in the state would help fund fencing for that. So maybe someone else knows the answer to that, but I seem to remember that in the past before I was a legislator. Thank you. Oh, Game and Fish, maybe.
Oh, yeah. Yeah, Co-Chairman, thanks.
Yeah, thank you, Mr. Chairman. So if I recall, we had a lengthy discussion about elk damages in this committee. And I believe part of that discussion was the compensation for damages is covered under those damage, or for fencing damage is covered under those damage claims through the Game and Fish. So I think we already have that part taken care of. If somebody remembers something different, correct me, but I think that part of the discussion has been taken care of.
Anybody else? Representative Davis, anything more on that? I guess we'll keep that in the conversation here.
That may be a good point, but somewhere in the back of my mind, I don't realize that we determine who the wildlife belonged to and what the compensation would be. So I'm a little gray in that area.
Okay. Representative Johnson.
Thank you, Mr. Chairman, and Representative Davis. I believe that the state of Wyoming owns the wildlife and that they compensate the landowners for fence repair. And they also go to the point of having having elk deemed as a nuisance and have them have license to shoot them on site when it gets to the point. Thank you.
Thank you, Representative. Anybody else? Representative Ottman.
Thank you, Mr. Chairman. And just a point, because I'm not expecting this to be done today, but one of the things here in Fremont County and possibly around the state as we get more and more buffalo herds is that we need to differentiate, especially when the borders are tribal and the state of Wyoming. Are those buffalo designated as wildlife or are they designated as livestock? That is a conversation that is going on because of problems, but I haven't seen either government decide to take a stand or fix this problem. So I'm just voicing it because it needs to be determined whether or not, or how we're going to determine, are they wildlife? When are they wildlife? When are they livestock? And if they're livestock, how to handle that, possibly with what we're talking about today with 3 strikes, possibly about reparations or whatever. But it's a conversation, probably not for this topic, but one that I hope people keep their eyes and ears open and that we do not ignore it. Thank you.
Yeah, thank you, Representative Ottman. Any others from the committee? Okay, well, we've got cattle operators and sheep operators up here. So it's a good place to get started with Mr. Magagna. Go ahead and bring us up to date. You know a lot about this issue and representing the stock growers. This is a good time to deal with this. Thank you.
Well, Mr. Chairman, as a lifelong sheep producer who represents the cattle industry, I started sitting here feeling like we're back in the sheep and cattle wars of the 1800s. And I don't know if I'm going to have to choose sides or not.
We hope you do.
Anyway, Mr. Chairman, appreciate the opportunity and did work with LSO some as they developed materials for you. And because it is a unique area in Wyoming, quote, law, because it's not in statute. The fence out principle was when in the early days, we rejected the common law principle that you fence your livestock in and said in Wyoming, at least for cattle, we're going to fence them out. And I think that the sheep industry didn't find that as objectionable because in those days, sheep were mostly herded. They weren't building fences for sheep for the most part. So anyway, that's the way that history has evolved. And our statutes dealing with fencing really have not been altered in any meaningful way, with one exception as to state trust lands 2 years ago. Since who knows when, and I guess the best indication, if you read the entire statute on fencing, there's only one criminal penalty, a misdemeanor in there, and that is for building an illegal fence. And the fine is from a minimum of $5 to a high of $25. That tells you that was put in place back when gasoline was 17 cents a gallon. So some need for update certainly we could say exists today. I might just briefly address the wildlife issue for going back. That is in the game and fish statutes that they're responsible for compensating for both damage to improvements on the land, which would be fencing or water developments or that, as well as to, the term is used, extraordinary damage to grass. And we've had some, on the improvements, Game and Fish has always been pretty well, and they do pay that. That's all paid out of license fees. On the extraordinary damage to grass, we were having some severe problems. That was the basis behind legislation that was brought 2 years ago. The legislation didn't end up passing, but as it accomplished its purpose, because we were then able to sit down with Game and Fish and significantly strengthen their provision for making payments for extraordinary, quote, extraordinary damage to grass. If you lose more than X number of AUMs of your forage to a wildlife species, then you can be compensated for that loss of forage as well. And the other point that was brought up, Game and Fish has taken a couple of other steps in areas where elk populations, and that's the big problem, exceed the established population levels that they have created. A landowner's been able to step in and get up to 20 permits for cow elk, because that's the key to reducing populations, that you could give to anyone you chose to. And then in an instance in southeastern Wyoming of really excess populations, the past 2 years, the Game and Fish has hired professional hunters to go in and kill. First year, I believe, it was 130 head. This past year, 260 head. And those elk had to be harvested, and all of that meat was donated to the First Lady's food program. So they are becoming more active and more aggressive in addressing some of those problems. It doesn't mean they don't still exist in some places. But back to the issues here, and as I say, the only criminal penalty is if you build an illegal fence. But if your cows or whatever the animals may be tear down somebody else's fence, all you have is civil penalties. And there's two key principles in the statute as it exists now. If I put up a fence, I can require my neighbor to pay 50% of the cost of that fence, as long as it's a legal fence. And also 50% of the cost of maintenance of that fence over time. If they fail to do so, I can file a civil action against them to collect payment of that. But there is no criminal penalty involved. So I can't call the sheriff and say the neighbor's cows are knocking down my fence because the sheriff has no authority to do anything currently under the way the law is. So there's no criminal penalty for failing to pay your half of the cost of a fence, and there's no criminal penalty to pay for allowing your animals to do unrealistic damage to the neighbor's fence. Under the current law, there's only liability for payment, which requires the fence owner then, if it's not done willingly, to file litigation and go through the cost of litigation. So there's certainly is some room for potential changes there to address that part of the issue. And I think that it certainly is worth exploring the idea that Senator Pearson put forward of incorporating a criminal penalty in there as well, at least on repeated offenses. If I put up a fence and bill my neighbor for 50% of the cost of it and everything is right and the neighbor just ignores it, that perhaps there would be a criminal penalty. And certainly if the neighbor allows their livestock to just destroy my fence, that I could notify the sheriff and they could issue a citation and there could be a criminal misdemeanor penalty, at least for repeated valuations. Perhaps 75 years ago that wasn't necessary. We were all a little more neighborly than we are today, perhaps. But today, I think that that's an approach that is worthy of being looked at to address that. You did, as the legislature, address state trust lands 2 years ago, as I recall, by saying that if I'm a private landowner and I put up a fence on a parcel with a state land that is, the lease is held by someone else, I can force either the state Office of State Lands Investments or that lessee to pay half the cost of the fence. It started out the state land would have to pay it. Then it got changed that if it is leased for grazing, state lands can pass that burden on to the grazing lessee. So that part is covered. There is no coverage if the neighbor happens to be public lands, federal lands, BLM, or in most cases, or Forest Service, that the livestock are coming off of, that are destroying my fence. And that's one that deserves some thought. I don't think we could, there's no way we as the state that I'm aware of would be able to force the BLM to pay for that fencing, but we might be able to do something that would pose that burden on whoever is the authorized permittee to graze on those BLM lands, that they would have to share in that fence. That would need some legal analysis, I believe. Would certainly be worth looking into whether that could be a part of this, because in many instances, it doesn't involve just private, it involves private, federal in many parts of the area. So I think that one is worth looking into. But as much as we want to stay away from criminal things, I think this is an area where it could very be appropriate to put in place to support the current civil liabilities with some criminal activity or some criminal offenses that would motivate people to work a little harder together to resolve some of these problems. The other issue that comes up, and perhaps it does or does not need to be addressed, I believe I approached this committee about 5 years ago with just the need to update the definition of a legal fence, because things have changed. The type of fences we built 50 years ago aren't necessarily the ones we build today. Electric fence is commonly used today, not often as a boundary fence, but occasionally, and it can be effective. And now to go all the way, virtual fencing with these collars is beginning to gain a lot of momentum. So if I put collars on my cattle to keep them in a pasture, and I have the ability to control them off of my cell phone, quite frankly, and I know people who do that today. They can control their movement just like keep your dog in the yard using that type of technology. If an occasional one escapes, I probably shouldn't have criminal liability, but if I purposely set the boundaries on my fence, I know my neighbor's out of town for this week, so I'm going to set the boundaries so the cows can go over there and eat this week. There ought to be some penalties involved in something like that. So there is opportunity. I think this is, in general, an issue that's worthy of being looked at to see how we can maintain the principles, and we would strongly object to any effort to change the well-established principle of a fence out for cattle. And it's always been described to me as cattle and horses. I don't know if it's ever been tested in the case of horses. And I'm not talking about wild horses. Now I'm talking about domestic, privately owned horses. And has been brought up, it becomes an issue again now with bison, where we're seeing not only restoration on the reservation, but bison in other areas. And I know the Game and Fish has been looking at that one and need to do a little more research on where they may be with looking at that issue today, how they're going to treat bison. Because I thought they were at least discussing maybe treating bison as wildlife, at least in the area around the reservation, so that then they could have the authority to deal with them when they've drifted off the reservation. But I'm not positive on that. I think that needs to be looked into further. But with that, Mr. Chairman, I'd be happy to take any questions.
Thank you, Mr. Magagna. Representative Davis.
Thank you, Mr. Chairman. You know, and also, Jim, along the wildlife corridors now, we are removing the old woven wire, put in wildlife-friendly fences, you know. So there's been a lot of nuances, like you're saying, in our thought pattern on fencing, period. You know, over there in our area, there's been well over $1 million of federal dollars in these initiatives to change them woven wire fences that kept the sheep in. And now it was also an issue with wildlife. So there's a lot of discussion here that we need to look at. And as far as the virtual, you know, the Forest Service now is preferring that instead of fence maintenance up there. And so with satellite technology, I mean, there's a pretty broad future on fencing.
Mr. Chairman, I certainly would agree with that. And, you know, as far as removing the net fencing, and if it's private land, that's usually even for wildlife corridors, it's done with arrangements with the livestock owner or landowner who says, I'll do it. And if we do certain things, that where it's become a bit of an issue, and I've dealt with this one a little bit on a personal basis, is where, for example, YDOT is wanting to replace net wire fencing with 3 or 4 strand barbed wire, with the lowest wire high enough that the elk can go under it, and the highest wire low enough that the deer jump over it. And in many instances that perhaps at one time ran sheep and don't anymore, that's fairly agreeable. But in some instances where there's still sheep being operated, that's been a concern. I know they've reached out to me on a couple of cases like that to get our perspective on changing those types of fencing. But the other thing that Representative remarks bring to mind, and I would want to be very cautious if we're going to redefine legal fencing, there may be some pressure to say, well, a legal fence has to be a wildlife-friendly fence. You know, we're very supportive of having wildlife-friendly fences. In most instances, properly constructed, they can meet the needs of the livestock producer as well, but not in all instances. And we would certainly have a serious problem with anywhere putting in statute that a legal fence had to be a wildlife-friendly fence. That I think is subject to negotiating of the parties under the circumstances.
Yeah. Yeah, one size fits all doesn't work with fencing. Very good in Wyoming anyway. Committee, yeah, go ahead. Senator McEwen.
Is it just this area that they're having issues with buffalo or bison? I know that there's a huge bison ranch up in my neck of the woods, and they actually double fence to keep them in. It's quite an expensive animal by the time you get ready to take it to market. Is that a problem prevalent across the state or just this area?
Mr. Chairman, Senator McEwen, you know, until recently, there's only been 1 or 2 operations with buffalo privately owned, and those are livestock when they're privately owned. In the case you're talking about, one down in Laramie County with the Bison Ranch. And those parties have been, to my knowledge, very responsible in building adequate fences to retain those animals. Now, there is talk about other people, particularly some people are coming in acquiring ranch lands in Wyoming that want to convert them to bison ranches, and that could become in the future an issue, and it might even be, again, if we're looking at legislation, should we define in legislation what is a legal fence for bison? It may be different than what is a legal fence for cattle, because there's a movement afoot right now, and quite a battle going on in Montana, in fact, over bison being put out on vast expanse acreages of land, and as you've pointed out correctly, the fence we put up to hold our cattle in is not going to contain bison. But I'm not aware that we've had major problems in Wyoming to this date, but looking ahead, that could certainly evolve.
Yeah, go ahead.
Have you seen the fence that's up around the Durham Ranch?
Mr. Chairman,
Between
yes, I
Gillette
have.
and
I've
Wright?
been up there several times, been on that ranch a time or two.
That's quite an impressive set of fences. Thank you.
Representative Davis.
Once again, Mr. Chairman and Jim, we have Yellowstone Park up there. The buffalo migrate, the elk and deer, and all the wildlife friendly fences there. So this is going to be a tough one to move forward. A lot of consideration here, and it's not going to be a one size that can fit all across this state.
Yeah, Mr. McGagnon, you brought that up, that battle in Montana on the buffalo, and looking at, I think it was kind of over federal, grazing permits for buffalo and how buffalo are designated, whether they're domestic livestock or wildlife. Do states have the prerogative to define what a buffalo's, if it's domestic livestock or wildlife? Thank you.
Mr. Chairman, I would say that we certainly have that prerogative in terms of how we treat the animals in Wyoming on private lands, on state lands. What happened in Montana is that the BLM decided that under a grazing permit, which we've always determined to be sheep, cattle, goats, that you could now run bison under that permit.
Exactly.
And they granted that. Now, that's just recently been reversed, just within the last couple of weeks now.
Oh, really?
So BLM is no longer, under the current administration, going to allow bison to be grazed on public lands as livestock. But I don't think we, at the state level, couldn't control that, but we certainly can control how we define them in terms of, do they fall under the jurisdiction of our Wyoming Livestock Board because they're livestock, or under the jurisdiction and certain conditions under the Game and Fish because they're wildlife. That would be up to the legislative prerogative.
Good, thank you. More questions, committee? You don't need to leave. You might stay here. If we discuss this, I think you might be a big part of the conversation if you don't mind.
Mr. Chairman, maybe I better leave so you can have a more honest conversation. Thank you. Appreciate the opportunity.
Yeah, thank you. All right, committee. Any further testimony? Yeah. Mr. True, Director. Go
Mr.
ahead.
Chairman, Committee, Steve True, Director at the Wyoming Livestock Board. I just want to address a couple of questions. Currently, the state does have a joint rule between Game and Fish and my agency on how live buffalo are designated as livestock and or as wildlife. And we also have a rule in there on how we handle those situations. The Fremont County excursion that the buffalo went on was handled via this rule and is completely under control. One suggestion I would make is, or one comment I would make is, we testified at length with Select Tribal late last fall on this issue. And I'm curious as to whether that would be the proper venue for this discussion to take place, as these are tribal animals that were at question there. So I would say that currently within the sovereign nation of the reservation, buffalo are classified as wildlife. Couple of reasons for that are tribal and funding wise for U.S. Fish and Wildlife funding. The minute they stick their nose across the line, they're mine. They're domestic livestock. So there are only two herds that are currently classified as wild. That's the Absaroka herd and the Yellowstone herd. Everything else is domestic bison, unless Game and Fish and my agency designate them otherwise. So there's currently rule in place for this, rule on how we deal with removal of privately owned bison, which falls under my agency's purview, which we did in that case, where we determine ownership and we work through the proper channels to get those bison returned. I understand there's some angst between some producers that those bison did get on, they got on their property and how that works, and a lot of misconception about what our authorities are and are not. So I'd be happy to go into that, but I did that ad nauseum with Select Tribal and could do that at a future meeting with you guys if you want to, but there is rule in place, joint rule between Game and Fish and the Wyoming Livestock Board. It's Rule 41 under Game and Fish rules if you want to go look at that and see how we deal with those situations. And I would say that one of the best things that happened out of that, there are two tribal herds. There's a Shoshone herd and an Arapaho herd under the banner of the Wind River Buffalo Initiative. The leader of that initiative took these were Arapaho bison that got across the river in an area where the fences were not buffalo fences yet. I know they're funding and working on getting those built, but those bison are all up farther north on the Shoshone property now, and they're fenced in. That's state-of-the-art buffalo fences they have up there. So just wanted to clear that up real quick, that there is process, there is definition, and it's already in there. Take a look at it if you want to talk about it. I'm sure we'll be at Select Tribal, not this first meeting, but maybe later on to do this again. So just wanted to make those comments.
Thank you, Mr. True. Yeah, go ahead, Representative Ottman.
Thank you, Mr. Chairman. Mr. True, it's good to see you. When I talked to you the last time at Tribal or at a meeting, I had asked you about that, and I didn't see what I was told at that time, and we will again have Tribal Monday, Tuesday. So maybe you'll be at those meetings, I'm not sure. But what you told me was that they are not, or what I understood, was that since the buffalo are not branded, that there's no way to tell whose they are. And so if they come across and onto private land, the responsibility of the livestock board is to identify brands and return them if possible. So now I'm hearing there is a rule that covers all this. So I'd like to hear what that is. And secondly, I heard you say that there's two tribes, the Absaroka and the Yellowstone, that are deemed wildlife. So what are the Shoshone and Arapaho? Because last I knew, and I talked to the Game and Fish for the tribes, they had not determined. They said, yes, the elders said the buffalo were wildlife, but that had not been put into any of their rules. So I'm hoping that it's all fixed. But when I talked to you, you were pretty much, it's not that. So that's been a few weeks. So maybe a lot has happened since then.
Go ahead.
Mr. Chairman, Representative Ottman, you and I had a communication problem. What I said and what I said at the meeting up there is that my brand inspector did not have the authority to identify ownership because those are not a species listed under what we inspect. We inspect sheep, cattle, horses, mules, and asses. We don't do buffalo. But however, in the rule, It is the agents of the board, myself, Dr. Hazel, or my investigators that can identify the ownership of those bison, which we did through contact with the tribes who admitted freely that those were Arapaho bison and they wanted to come get them. I had no reason to believe they were different because we had already done search of the other closest privately owned bison. So we knew that. I accepted their ownership claim. We offered to the folks that they were on to let the tribes come and get them. So there is a venue in that rule, and I don't want to take your time today to read that whole rule, but there is in there how I determine ownership of those bison. So the main disconnect we've had, and I'm probably not very good at explaining that, is the gentleman with the complaint kept saying that the brand inspector needed to identify ownership. He cannot. He has no authority to do so because they're not under what we inspect for species. However, in this joint rule, the agency has an avenue to determine ownership, which we did. So that's that part of it. The second part of it is I understand that there's some differences within the nation about whether that's final or not, that they're determined as wildlife. I haven't talked to Jason for a while, but that's where I understood it was going to go, that the tribes would designate them wildlife, and that if that's not official yet, I don't know. They've made an announcement that it was, and that still doesn't affect the way that what I call them if they get off their territory. They're still domestic bison to me because those are maintained bison. I hope that makes it a little more clear. If not, I can try it again because I still am not probably the best.
Follow up.
Go ahead, Representative.
Yes. Okay, Mr. True, thank you. So basically what I'm asking is if those buffalo come across, okay, the brand inspectors, that's the normal procedure for animals that come across or come onto my property. So since they do not have authority to do that, so somebody's called. Mr. Baldes is not the authority or the one to do that. Game and Fish told me that the tribal Game and Fish told me that the tribes had said, yes, they're going to be wildlife. That government has changed and it was never put into their rules. So what rules are we talking about?
Mr. Chairman, Representative Altman, I'm talking about the Game and Fish and Wyoming Livestock Board Joint Rule 41, which designates everything as domestic if it doesn't belong to the Yellowstone herd or the Absaroka herd. So everything else in the state is domestic. So that means when they were on state property, when they crossed the river and got on the producer's boundaries, they're domestic bison to me, they're livestock. However, again, it's the fact that my inspector, and I love the fact that my brand inspector supervisor went out there in the middle of the night to get with him and say, yep, those are buffalo. And he's well knowing who they belong to, but he can't claim it because he has no authority because he doesn't inspect them. However, in the statute, or the rule, it says any privately owned bison as determined by the board or its designee found to be running at large shall be removed by the owner within 48 hours. Mr. Valdez was on that. He was coming after him right away. So everything by rule was dealt with there. I accepted their claim of ownership after my inspector ran a quick study around the area to see who else had domestic bison, and those were all at home. So these had to be that group of bison. And the tribes had already admitted that those were their bison. So we went through all the steps in the rule on how to deal with those as privately owned bison. That's what they are when they were on state property. When they go back to the tribes, at this point, they're whatever they call them there. Doesn't matter to me. I have no jurisdiction over them when they're there. I only have jurisdiction over them when they wind up on state land.
Follow up, please.
Yes, go ahead, Representative.
One more time, Mr. True. Okay, those animals, okay, because I know this is it can be very gray on who's talking or whatever. Those animals are determined to be, or what they're trying to do is to say they're wildlife. Okay, So what you're telling me is that when they cross over onto private property or deeded land, that they are domestic. So what is the cause of action then? According to Rule 41, it's you have 48 hours to remove them. What if, okay, so that's wildlife to domestic, correct? So it'd be the same with an elk or whatever? No. Okay. So how does that determination of domestic come on to where they have 48 hours and the landowners to handle it? I guess I just want to know what would be my rights as a property owner to say, because Mr. Baldes does not own all those buffalo. That is the tribes, and it's totally separate, said the tribes. Okay, so please just help me to understand this.
Go ahead, Director.
Mr. Chairman, Representative Ottman, so no, the rule pertains only to bison, not to other wildlife. The simple way to say it is what I think I just tried to, is that if they're on tribal property, that's their designation. If they come onto state land or private land, which is state land, which is not the reservation, then they fall under my purview as domestic bison, because the rule identifies those two herds as the only wild herds in the state. Everything else is domestic. So then there is a process within this rule, and I don't want to read the whole rule to you again, but I sure can. I've got it right here. Co-Chairman Banks is telling me don't do that.
Okay.
So
Would you forward it to me, please?
I can,
That'd be
and for reference, it is in the Game and Fish Rules, Chapter 41, bison designated as wildlife, and it's a joint rule which allows us, if they're considered wildlife, and Game and Fish was contacted, we were contacted, and so we dealt with it as domestic, which is the way we needed it to go. I understand Mr. Baldes does not own the bison, but he is the superintendent of the Buffalo Initiative. So he's the guy, he's the caretaker for those bison. I was unable to contact the Arapaho representative of those bison, but Mr. Baldes spoke for him, and it was his troops that came and got him. So I understand there's two separate herds there. I understand they're tribal. I understand he isn't the actual owner, but he would be the operator. In an owner-operator situation, he's the operator. He operates that program. So it was him that I worked with, and my investigator worked with, and Game and Fish worked with.
Mr. Chairman?
Go ahead, Representative.
Okay,
No, you're good. Keep her going.
okay, one more time. The Arapaho tribe have buffalo. The Shoshone tribe have buffalo. Mr. Baldes, with his initiative, have buffalo. They are not all the same owners. They are not. The people in that last tribal meeting said themselves, the people of the tribe said, are they ours or are they yours? And that was never determined.
Go ahead.
Mr. Chairman, Representative Ottman, that's a tribal issue. That's not my problem. All I know is the buffalo that came off of the reservation and came onto their private land are managed by that Wind River Buffalo Initiative. And so that's who I dealt with in that case. I'm not going to get into who owns it in the intertribal squabbles. Not going to happen. So I'm just telling you what we deal with. Those bison, everything they have on the reservation as bison is considered domestic to me if they intrude on state land. On the reservation, their own designations, their own ownership conversations are their own. They are not mine.
Mr. Chairman.
Yes, go ahead,
Okay.
Representative.
Mr. True, not to frustrate you, but just to say this is exactly why I'm trying to get answers to it, because what I'm hearing is you have a point of contact that you have to get to. I want to know how you determine that, and because if my cows came over on your property, you would contact me. But who do you contact? Game and Fish should be the contact if those animals are wildlife on the tribe. It should be tribal Game and Fish. And if they are domesticated, then it should be. So how do you know? Because what you told me was that the brand inspectors don't know who to contact because there is no brand on them. So determine, and rightfully so, who do you contact? Tribal Game and Fish or who? Those buffalo were not Mr. Balde's. They were not that initiative. They were from the Arapaho tribe. So how are they contacted in order to know, are we going to be able to treat those animals as domestic or wildlife, or what can we do? Mr. Baldes is very good about handling things, but they were not his. And so what I was asking was, are they going to be, people ask me, so should they be able to be hunted? I don't know. And are you telling me, Mr. True, are you telling me that Rule 41 handles all of these situations? And if so, I will be very, very happy, but.
Yeah, Director, Senator Love, I'll let you answer this. We'll go to Senator Love and then back to, if that's okay with you, Representative Ottman. Go ahead.
Mr. Chairman, Representative Ottman, yes, Chapter 41 rule handles all those situations. My investigator did talk to the chief of Tribal Game and Fish, who was on top of one of the drainages and could not respond. So that conversation was had. Again, I don't know who owns how many of which group of buffalo on the reservation. Well, you are asking me that. So I'm telling you, I don't know that. If they come off of the reservation, I treat them as X. And again, as an owner-operator syndrome. If they were the legislature's buffalo, does it do me any good to contact management council, or do I need to talk to the operator that's handling the herd? That's my question. And so I did that. I talked to the operator that's handling the herd. If you think that the situation needs to be more clear, the legislature can feel free. But we have that rule, and we followed everything in the rule to determine those bison and to return them to their proper space. They've been taken to a space where they won't get out again while those fences are being built. So I'm satisfied at this point. Designations, it's well within the state's purview to determine if you designate them differently. And then I will enforce whatever that designation is. I do not, and again, the tribal designations are their own. They are not mine. So I would say that please, I will forward you Chapter 41. Please read the whole thing and see that we followed that process in that case, and would follow that in any process. There is also a clear process for Game and Fish if the wild herds get somewhere where they're not supposed to be for what they do. So that's a different animal, and I'm not touching that. That's Game and Fish's program. So I hope I've kind of answered your question.
Yeah, and Representative Ottman, I want you to keep going. This is an important issue. I got tangled up in it too, so I think we need to sort this out here today, and I'll go to Senator Love.
Mr. Chairman, thank you. So I'm going to try to help this conversation a little bit. And so when we're thinking about the tribal lands, we have to think of it almost as a different state or a different country for that matter. They have their own governing body and their own laws. And so when those animals cross the judicial boundary, and let's say we're dealing with cattle on the Colorado side, and they get on a different landowner, it would be our responsibility to determine they're not Wyoming cattle, and then to call the neighboring state and say, hey, we have these animals identified as this in this location. Can you tell who they belong to? We're going to return them to Colorado. Colorado gets them, and from that point, our obligation is done. It's their obligation to determine who actually owns them inside of their own judicial boundaries and return them to the appropriate owner. Further, the state of Wyoming, I believe, has handled this appropriately because we do have wild herds of bison. If we accepted another state or another nation's designation as wildlife, under Wyoming law, the moment they crossed onto our property, much as an elk coming from Colorado, that elk becomes the property of the state of Wyoming. So there is no return to where it came from unless it decides to do that on its own. Us using the designation as domestic wildlife or domestic stock allows the state then to say these are not a wild herd owned by the state of Wyoming. These are private property of a different jurisdictional or judicial boundary. We contact them, we return it to their governing body, and from there, our obligation has been met. And so we label them as domestic, so when they cross that judicial boundary, we get them back to where they came from. And it's not our job to figure out who actually owns them. It's just to get them back across that judicial boundary from which they came. Once they're there, they can determine who owns them based on their own laws, regulations, and governance. If we had them as wildlife, though, much as that elk, when they cross that boundary, they become a wild herd of Wyoming and owned by the state of Wyoming, and the tribe would be without bison. And so I believe that's the distinction that we need to understand in how we're handling these things. And so it's okay that the tribe considers them wild and they roam and go wherever they want. For us, in order to properly manage them, we have to identify them as domestic and return them back across the judicial boundary from which they came. And that would be our sole obligation. Is that correct?
Yeah, just 1 second here. We'll try to contain this. We're kind of getting off subject here of Senator Pearson's fencing law bill, but it's a discussion that plays into all of this. So keep your comments succinct, and we'll try to finish this up and give Miss Representative Ottman another bite at the apple here. Go ahead.
Thank you, Mr. Chairman. And Mr. True, I know that this probably will not be the last time that we discuss this, but I will look over Game and Fish 41, and I also will continue to make a couple of phone calls that I need to make. And again, I don't know if it's an issue tomorrow or Monday and Tuesday at tribal meetings, but it's something that needs to be understood by the state and also by the landowners. Because if it's clear in these rules, then the landowners need to understand that so that those problems are not brought out in such a aggressive way. And so to determine if Mr. Baldes, as a different fee owner, is allowed to instigate or interject into the answers for these problems is another thing that I would look at, as because he was not the owner. But anyway, I'll drop it for right now, but thank you for that information. And I don't, as legislator, I'm protecting my constituents. I am not going to battle with an agency. I'm looking for answers, and I would appreciate that.
Go ahead, Senator Pearson, and then I'll let you finish up and answer Senator Love, Senator or Representative Ottman, and any questions from Senator Pearson.
Thank you, Mr. Chairman. So, Mr. True, I would ask, or I'm wondering, do we need to change the Wyoming Livestock Board's rules to include bison as far as brand inspections, things like that? I mean, do we need to add bison on there? Thank you.
Mr. Chairman, I'll take that one first because it's please no. No, we do record a bison brand, and in fact, one of the other producers near the tribal area brands their bison just so they won't get confused if something like this happens. But we still, under state law, we don't inspect them, and I don't want to. That's a tough game, and I don't think any bison producer wants one of my guys standing in the alley while they're trying to load those things. So yeah, we're pretty happy with the state statute and designation at this point. Thank you. To Senator Love, what he said. he explained that in a different fashion that I think catches that. That's actually where I was trying to get, is once we return those and those bison are back, we're satisfied that they're back where they belong, that that's where they belong to begin with. Then they're back under tribal dominion. Then they're not my problem once they get them home. So I do agree with that. And I understand this is kind of a sticky, hard to understand. And one of the problems that happened with this is it was stated repeatedly in the media and everywhere what my brand inspector's authority was in an incorrect fashion. What I told you today is what my inspector's authority is as far as it goes. I'm still really happy with him for going out there in the middle of the night and trailing and trying to see them all and saying, yeah, I think I know where those come from, but I can't identify them. And that's because they're not under his authority. They fall under my authority, my chief investigator's authority, and the state vet's authority in those conditions. So that's how that works. So be happy to explain this farther at any other time, but I'm taking too much of your time today. So just wanted to clear up that little piece of it to begin with. And darn if I didn't open the lid on the box. So I'm sorry, Chairman. I'll go back to my chair and be quiet now.
Thank you, Director. Representative Ottman, we're on your home turf here. I want to give you every opportunity you can. You were in the middle of that and trying to represent your constituents. So if you want to add anything here.
Mr. Chairman, I appreciate that. There's a lot of details in there. So I've tried to document what you've said today, and I'll be able now to watch it on video. And so when I am approached again, I'll be able to say, okay, let's look at this and see if there needs to be clarification somewhere or a change or how to do those things. So I appreciate the time today. Thank you very much.
Yeah.
Mr. Chairman, and I can send this to the whole committee if I want. I had prepared a sheet of all of our authorities in these cases and kind of a flow chart. So I'd be happy to send that to either LSO or to all of you so you can see what I'm trying to explain. And I appreciate your opportunity, appreciate the questions.
Thank you, Director. Go ahead, Ms. Clark.
Thank you, Mr. Chairman. Karen Clark with the Wyoming Farm Bureau Federation. I'll keep it very brief here. Fence out is that common law principle of fence out is something that the Wyoming Farm Bureau Federation has always supported. And the topics here today, we've talked about a lot of different new things that have been used with fencing, and virtual fencing is one of those. And we have many members that are starting to look at that technology and utilizing virtual fencing. That said, it is a technology that is still yet to have a lot of testing done to it as well. So as we talk with our members and what they are looking at and what they're going to be watching for and making sure that they are correctly utilizing that technology. So that's another area that has been discussed here today. But again, we just close with supporting the supporting the common law principle of fence out for cattle here in the state of Wyoming. Thank you, Mr. Chairman.
Thank you, Ms. Clark. Questions from Ms. Clark? Anybody? Thank you very much. Yeah. Any other testimony here today? Come on down. Go ahead and introduce yourself and tell us what we need to do.
Thank you, Mr. Chair. My name is Joy Hill. I'm here representing WyoPass, the Wyoming Planners Association. I'm the vice president. Melissa Ruth was here. She unfortunately had to go back to Cheyenne for a meeting. The topic that you're speaking of, the livestock fencing issue, this is actually related to subdivision fencing as well. We did provide some information in advance of this meeting. We've been working with WCCA and also Representative Banks on this particular topic. Obviously, you already know the whole fence out state doctrine and how everybody recognizes fencing to be fence out. In 2011, Wyoming statute included a requirement for fences to be constructed around subdivisions. And this was in Title 11, and planners were not aware of this, most planners. And so even though people were subdividing and they were supposed to put up a perimeter fence, I don't think that was really happening. It certainly wasn't happening in Park County, where I'm from, and several other counties have indicated it wasn't happening there. In 2023, statute changed. The Title 11 statute, which was 1128-106B was repealed, and they slid this subdivision fencing requirement under Title 18, under the subdivision statute. And I did include that particular statute in your packet. When this happened, and this is very germane to what's just been discussed, it left planners hanging. So we're told that you have to provide a perimeter fence if there's the potential for livestock to run at large adjacent to the subdivision. Well, nobody defined livestock. So if you look in statute, I can point you to seven different statutes that define livestock in one way or another, but they could be anything from a bison to a rabbit. So can rabbits run at large next to a subdivision? I don't know. I assume yes, they could. I don't know of any law that prevents a rabbit from running next door. So as a planner, now we're left to decide, okay, well, we have to make subdividers fence in a fence out state where it's your choice, but now it's not your choice. You're being made to do it. And we now have to figure out how to achieve that through the subdivision process. The 185319, gives you the option to say, hey, if the
Could I interrupt you real quick?
course.
I've got a quick question from Senator McEwen before you go further. Thank you.
Yes.
When you mention rabbits, are we talking wild rabbits or domestic rabbits?
All I can
And I'm
tell-
not trying to necessarily be funny because my yard's full of all kinds of cottontails.
Mr. Chair and Senator McCune, I can tell you that the rabbits are part of, and let me just read it here, 23-102A6 and 1129-101A6. So I pulled as many definitions of livestock as I could from statute and trying to make the point that I don't know. I don't know how to answer your question, whether it's a domestic rabbit or I believe in those particular statutes, it's probably relating to domestic rabbits, but I don't recall.
Just curious. I'd like to shoot a couple of them and eat them.
We almost hit a couple of them on our way here. So as far as WyoPass is concerned, and again, we represent the planners in the state, and that's not just the local government planners, but also, private industry planners. We believe it would be very helpful for you to review the fencing statute for subdivisions. We have offered three options for you. First would be to just repeal the subdivision fencing requirement. In particular, this option would align with the statute, or I should say the doctrine of Wyoming being recognized as a fence out state, but it also would align with other state initiated legislation that is aimed at reducing the cost of housing. Fencing is extremely costly. And if these subdividers have to build fences, that's an additional cost to them, which will then be passed on to the future lot owners. It also aligns with statewide efforts, which have already been discussed today, as far as unnecessary fences being eliminated that prevent the passage of wildlife. And also it supports local control for fencing requirements for subdivisions and leaves that in the hands of the counties who have to authorize these subdivisions. If that's not possible, obviously, if you're not interested in a repeal, then we would offer the second preference, which would be to adjust that language. One of those adjustments could just be to give county commissioners the authority to decide how that fencing should occur. This gives local control. It allows for some flexibility. It could also offer that not all subdivisions would need to be fenced. We have a lot of 1, 2, 4 lot subdivisions and upwards of 60 and 100 lot subdivisions, and maybe it would give us some flexibility to decide which ones would be appropriate to fence. Finally, which is the least preferred option, if you choose to keep the statute, we would certainly love to come to the table and have some discussion about how it can be improved. The number one thing that we would love to see improved was just a definition of livestock. How do you define it? Which other title could we refer to determine what livestock you are referring to? We think we know, but we don't want to make that assumption. It's a dangerous assumption. We have broken down this particular statute line by line for you. And I had 15 county planners weigh in creating this document for you. all of their comments have been incorporated. So you could literally go and see, how do you define adjacent? You know, when you're talking about an adjacent landowner could say, hey, we don't think you need a fence. But it talks about the subdivision perimeter. A perimeter is an entire enclosure. Well, so if one neighbor says, no, you don't need a fence on that side of the subdivision, but then all the other perimeter adjacent landowners say that you do need a fence, now, our interpretation is that you have to have the fence, right? Like if all the other ones say, no, you don't need it, but one says you do, you're putting up a fence. And that's how we're interpreting it in Park County. We've had to impose an affidavit requirement because we are not fence experts. And this statute refers to it having to be a lawful fence, which you obviously define. There's multiple types of fence that could be considered lawful. But we don't have the resources to walk a fence line, measure it out, make sure that all the barbed wire is where it's supposed to be. And what happens if that fence gets torn down tomorrow? So we're requiring an affidavit. We require the subdivider to say, yes, I have constructed a legal fence per the statute, and we give them the statute that defines the legal fence. Other counties are struggling with this. So anyway, I'm not sure if it's 100% in alignment with what the argument is today and the livestock fencing issue that you're discussing, but I think it closely relates, and it certainly has become a problem for the planners around the state and for the developers too. And we would just really like to try to come to some maybe improvement or solution to this problem. And I stand for questions.
Thank you, Ms. Hill. Questions from the committee? Yeah, Representative Vaughn.
Mr. Chairman, and maybe a question for you. What document? Are you talking about the fencing document that we got from LSO, or what? I don't have what your...
So in advance of this meeting, Mr. Chair and Representative Ottman, we submitted a memo with some enclosures regarding our concerns about subdivision fencing. It has the WyoPass logo in the middle at the top. Yeah.
That's right after Savannah's memo in that section on fencing.
Thank you, Mr. Chairman. I just missed it.
That's great.
Sure.
Thank you.
Yeah, go ahead, Representative Straub.
What's that before? Thank you. I guess to repeal this, if this is something we're going to look at, I was wondering what even brought this to forefront. Why were we needing to have this bill? I don't remember. And if we were part of this, like if I was even on ag committee yet. And I guess my other thing was if it was because sometimes you get these subdivisions around people's livestock, and these people that move in do not understand that it's a fence out. So I think if that was somehow, we would have to clarify that, because then they're trying to sue you for your livestock getting on their place because they don't understand it. So I'm just really curious what started this whole thing.
Go ahead.
Sure, Mr. Chairman, Representative Strzok. Back in 2023, when this particular law was changed, it's my understanding that I believe it was Senator Steinmetz who brought forth the bill on the fencing. I can only speak to what I heard. I believe there may have been an issue somewhere in the state of Wyoming where someone's cattle trespassed onto someone's land and caused some damage. And then that led to this particular discussion in 2023. I do know that during that time when that bill was brought forth, the planners did come forth and we provided all of this very information line by line, like our concerns about where this was going to go. And I believe the only change that had been made to that original bill was just addressing the adjacent landowner being able to say yes or no offense will be required. So, you know, we tried to communicate the concerns about the definitions, about the different aspects of it that were going to become our problem. And I believe they just sort of fell to the wayside. So other than that, I couldn't tell you, you know, somehow this Title 11 fence law that was brought in 2011 just got wiped out. And then it got slid under us, under the subdivision title. And now really the planners are kind of stuck with it. And so that's where we are.
Committee, any further questions? Well, thanks, Ms. Hill. It is pertinent to the discussion today, but it's a little bit off topic, so to speak, on the direction of Senator Pearson's. But I think it's a good discussion item that we need to maybe address. And I don't know if it'll be today or not, or where we'll go with what we're discussing right now. But I appreciate you bringing this forward. Yeah.
Absolutely.
Thank you. Oh, yes, Senator McEwen.
I believe this bill came about because they started building houses next to cattle, and the homeowners thought it was the rancher's job to put the fence up. And the rancher said, "You got nice grass." And it's a fence out state anyway. I don't want to pay for it. And so I think that was the beginning of this. Is that correct?
Mr. Chair, Senator McKeon, I do not know the actual origin. I only know what I've heard.
And one quick follow-up. If we change this, does it change fencing requirements in an urban area also?
So, Mr. Chairman, Senator McKeon, the original Title 11, I believe, may have applied to all subdivisions under 18.5.306, which is counties. So I don't know that any of this applies to Title 15, which would be the municipal side. If there are fencing rules that apply to that, I'm not certain. I'm a county planner, and unfortunately, I don't know the city or municipal code or statute as well.
Thank you.
Sure.
Yeah, on that note, a lot of those fences on new subdivisions, the subdivisions within the city, and then everything on the other side of their backyard is in the county. So you kind of have a dual situation there with municipal and county. Would that be correct?
Yeah, and Mr. Chair, something to think about. In the county, people subdivide and they'll still use their land for agricultural purposes. So they literally could own the land next door, which they use for pasture, grazing, livestock operation. And now you're basically forcing them to put a fence up within the middle of their operation, which disrupts that ag operation. So, but yeah, with the city-county interface, it's just something we deal with. Irrigation issues, the same thing.
Sure.
It's very difficult.
All right. Well, thank you, Ms. Hill, for being here today.
Thank you.
Yeah. Any other public testimony? Have anybody online?
Mr. Dave Nisley again.
Go ahead, Mr. Nisley.
He's coming in. And Mr. Chairman, we have Edward Talaferro on. Please let me know if he'd like to testify, Senator.
I'm sorry, Katie.
We have Edward Talaferro online also, but he doesn't have his hand up, so I didn't know if he wanted to testify or not. So
Okay, thank you. Go ahead, sir.
Hi, David Nicely, Wyfresh Farm again. Some of you are aware that the city of Cheyenne attempted to annex us beginning in January. And for what it's worth, I've had my fill of government meetings for a year or more. But one of the issues is prior to them even beginning annexation, for a number of years, the city has been a bad neighbor, and erosion off of city developments and city streets have destroyed our fences. And I've asked them to fix them. And heretofore, they've been unwilling to fix the fences caused by their damage. But it has caused me in a weaker moment to consider getting a herd of cattle to challenge the fences that they've made 1.5 feet high because of their erosion, because we're a fence out state, and let them live with it. But then I wondered if, in fact, the fence out provisions of the state law apply within the city limits, or how they apply if you're in the county, but you're surrounded on 4 sides by the city. So I'd like, if this is the interim topic, some clarification and consideration of a situation where the city has annexed around an existing farm. How do the fence out provisions apply? A side note is the city has told me that the Wyoming Right to Farm and Ranch Act doesn't apply to us, and therefore we're subject to nuisance suits and enforcement actions that would be otherwise provided for by the Wyoming Right to Farm and Ranch Act. So I'd like some clarification with respect to that, and that might be another question. And then the second thing, or the third thing, depending on what you do with the side note about the Right to Farm and Ranch Act, is I'd like clarification that the state law provides that a good neighbor pays for half of livestock fences on the perimeter of a farm. I've told the city that and asked them to pay for half of the replacement of the fence. And they specifically noted that the state law doesn't mention cities being required to pay for half a fence. So I'd like the legislature to consider requiring the city pay for half the livestock fence, especially since they're consistently destroying it. Again, I didn't envision asking the legislature for this today, but you're handling the topic. And I do think that the legislature has contributed to the problem that we've got with the city because the legislature gave the city too much blanket authority to proceed and overreach with respect to our operation. And so I'd like you to address those three topics, if you would. Thank you.
All right. Thank you, Mr. Isley, and appreciate you coming back in. Yeah, this is a little bit of a sidebar conversation versus what we've started this discussion with, but your points are well taken, and I've noted that, and thank you for your testimony. Does anybody have any questions for Mr. Isley? Go ahead, Senator Pearson.
Thank you, Mr. Chairman. I'm just wondering, so our discussion today is about enforcement for landowners that are trying to keep livestock out, that are continually breaching the fence. So in your case, are you fencing livestock out and something's happening with the city that where livestock is breaching your fence, or is your fence to keep your livestock in?
We are
Yeah, go ahead, Mr. Isley, and yeah, keep your comments short if you could. We're actually a half an hour over our time limit here, but we want to hear your rebuttal to that or your comments to that.
Yeah, we're a farm that's the city has encroached around us and annexed around us. And the question is, if you're adjacent to city property, is the landowner on the border at the city line who's within the city, how does the fence out provisions of the law apply? As in, are they required to fence out livestock if they don't want them on their property? Or does the fence out provisions of the state law apply with respect to city property or property within city limits? So it is pertinent to the question if it's within city limits.
Yeah, go ahead, Senator McEwen.
So if those cattle break out into somebody's backyard, do they then become wildlife?
Wildlife's a different thing in South Cheyenne than in other places.
Thank you, Mr. Isley.
Thank you.
All right, committee, anybody else online with their hand up? Who is it?
Farrow.
Okay. try to keep your comments brief, and we'll try to listen to what you have to say today. Thank you, sir.
There. Can you hear me okay?
Yes, sir. Go ahead.
Okay, good. I just wanted to, one comment I had to make, I'm glad that I'm not the only one that has to deal with these electronic gremlins like I've been watching all morning with your speakers. Anyway, I just wanted to say I've been dealing with this fence out state stuff for probably 24 years. And it has to do with a certain operator. And, you know, when we initially started this down here, putting this farm in, all I ever got was it's a fence out state. So we built a fence and kept building fences. And, you know, between elk, deer, antelope, I can say, you know, cattle, you know, they keep taking the fences down and we have to repair them. And, you know, my biggest problem is there's no way we can get paid back on that. Or, you know, I guess you would say we can't get, we don't have any way to, you know, whether we call the sheriff or something, because apparently the sheriff and whoever's in charge get word that we don't have legal fences. Well, our fences are legal. I mean, they're net wire with 2 barbs, sometimes 3. And the only place that is probably not is along the river, where it's close to the river, because we live on a river that has a reservoir above it, which creates ice jams, and it generally takes out a good fence. That's why I'm saying that the fence out state law is, you know, I understand it for back when it was first put out. You know, Wyoming did this when they were a territory in 1876. And the state adopted it in 1890 when they became a state. But technology has changed since then. It does not take 2 weeks to a month to check your cows anymore. It does not take a week to get information to the operator anymore. And there's got to be some way to get compensated for the damage they do on, I guess you would say, irrigated acreage, because it's not just what they eat. It's what they destroy when they're walking across irrigated acreage. They break the crowns of the alfalfa, and that alfalfa's dead after that. And so I don't know, you know, I think it's a good start to, you know, the three strike rule that Senator Pearson has put forward. But still, you know, we've dealt with this for 24 years. And, you know, all we get is, you know, it's a fence out state. Well, you know, when I was living at Farson, running the farm up there, you know, your neighbors, if their cows broke in, they got them out, they fixed the fence. when we ran cattle, if anybody called and said your cows are around our place and we don't want them here, we went and got the cattle. We hauled water to the cattle. And if we brought cattle back there, they always had a herder with them. And that, I'm just saying, there's a deep lack of respect in some of these operators that don't care about anything but themselves. And that's a shame, because we don't do that. I mean, I never heard of the fence out state prior to moving down here. We never even considered it. So that's kind of my comments right now. And I just think it's from what I've heard, you're running on two different laws. You're running on common law for sheep, and you're running on, I don't know what to call it. I would call it maritime law for cattle, because it's corporate law. And so
Well, thank you, sir. We need to wrap it up here.
Yeah.
We appreciate your testimony, and I wish we could go on a little longer here, but we need to keep moving. Is there any questions? Yeah, Senator or Representative Ottman.
Thank you, Mr. Chairman, and thank you for allowing me all these times. I just wanted to make a comment to go along with this gentleman, but also Senator Pearson's bringing of this bill. I have a constituent that lives in a rural subdivision that had a neighbor come in and build a home there on just a couple acres, and had a bull that was very bull-headed. And so they fenced out because their flowers in their garden and everything was getting eaten. So they took it upon themselves, because it's a fence out, to go ahead and do that. That bull was one of those animals that needed to go to the sale barn, but nevertheless, it was still the intrusion upon that with no consequences for the bull owner through the county or through the sheriff or through whatever. So I think that approaching this topic and having all these conversations is a wonderful thing. So thank you very much.
Yeah. Okay, committee. Thank you, sir, for testifying today.
Yeah, could I make one more comment?
Keep it quick. Yes,
Yeah,
sir.
who determines what a legal fence is? We've never had anybody come out to determine, whether it be the sheriff, anybody like that.
It's a
Yet
great
we've
question.
contacted the sheriff, and the sheriff says, oh, you don't have a legal fence. Well, the only one that's seen our fence is the operator in question.
Well, hopefully that'll be in the discussion here when we get to it, and we'll probably cover that comment you made. So thank you, sir.
You're welcome. Thank you for your time.
You bet. Anybody else online? Any? Okay, committee. Discussion. Senator Pearson, you want to start us off and give us your ideas?
Thank you, Mr. Chairman. So in my introductory speech, I listed some ideas. I'm looking to the committee to, weigh in. Let's see, in my solutions, a criminal penalty misdemeanor of $750 or 6 months in jail or both per instance after 3 documented contact attempts with livestock owners to remove their livestock. So as Mr. McGagner referenced, my concern is not necessarily that we have a fence out state. There's no way that cattle producers in the state of Wyoming would be able to fence in. My concern is with repeat offenses and nothing being done to remove livestock. And over the past 24 years, it has been, and I'm going to say, there are other people around the state that are seeing these same issues, but I'm addressing this from our perspective, from our farm's perspective, that we have been dealing with this for 24 years. We have been told it is a fence-out state. These producers do not come and get their livestock off of our land. We have to do it every day. To the point that last year my dad was in the middle of the Green River with his dog running these cows out of our fields. Because we are on the river. And so I just think that there needs to be some sort of a criminal penalty so that these landowners don't have to pursue a civil litigation, because many ranchers can't afford civil litigation. There needs to be, we need to add in the federal land, not just state lands, but if the border is federal lands, and the leasee is, say, a BLM leasee, that they need to help maintain the fence or pay for half of repair of the fence if their cows are damaging the fence. And and I think that we also need to add bison in there, not just cattle, but bison as well. I mean, just like the issue up here, I mean, if bison, I don't care whose bison it is or whatever, but if they destroy a fence, then we should be able to say on repeat offenses, once again, I'm talking about repeated offenses. Because most cattle producers and most livestock producers, if you call them, they are there within 24 hours to manage their livestock. I am talking about those producers that refuse to manage their livestock and just say it's a fence-out state. So, but I think we need to add bison in there as well, so those are just some of my solutions. I looked at the committee to offer their weigh in on this, but this can't continue to happen to landowners across our state. Thank you.
Thanks, Senator Pearson. Yeah, Co-Chairman Banks.
Yeah, thank you, Mr. Chairman. The problem I keep running into here is, again, how do we prove intent? I mean, I got some ringy cows that get through the fence. I get them as fast as I can. It's nothing intentional. What do we do in those aspects? I don't want to be held criminally responsible for cows that just get out, and I'm trying my darndest to keep them in. They get out on my neighbors 3 times. And just hypothetically, if my neighbor is a anti-ag person that says, I just saw they passed this law. His cow's been on my land 3 times. I'm going after him. I understand the intention of this. I'm having a struggle with how do we prove intent to enforce some of this stuff.
Thank you, Co-Chairman. Senator Pearson.
Thank you, Mr. Chairman. Representative Banks, I agree with what you're saying. And maybe we put some wordage in there as far as producers that do nothing to remove their livestock. Or, I mean, I'm not talking about you. I'm not talking about those producers that, I mean, up at our ranch, we have people that have cows get in and, and yeah, it's been more than 3 times. But if there's a call made, they are there to manage their livestock. I'm talking about those producers that feel like they don't have to manage their livestock, that they don't have to have any accountability, that they don't have to have any responsibility in this. And that's what I'm talking about. That's why, I mean, I offered what I see based on our issue. but I'm asking for the committee to help me develop wordage or whatever to protect you, Representative Banks, because I understand what you're saying. But I think that this is an issue across the state, and I'm trying to protect landowners from those that are not responsible, are not accountable. And so I need your help to figure this out. Thank you.
Representative Davis.
Thank you, Mr. Chairman. This is an in-depth subject here, but, listening to the discussion here, there's several things that we are trying to blend into one bill, which makes it even more difficult. But definition of classification of the animal to be fenced out. What type of fence are we talking about? Should be number one, whether it is the rabbits or it is the buffalo. What type of fence? Or is it a turtle? I mean, the next thing that we seem to be going across here is the state of Wyoming is very diversified. We have private lands, we have federal lands, we have both BLM and forests. So we need to consider what rules they have when we're developing this. And so I think if we would go to, I guess, LSO again and get more information, check with what the BLM requires for fencing on federal grounds. Perhaps there's a difference between that than fencing on private grounds. There's also a difference between that and wildlife fencing on these corridors that seem to intermingle with private and federal grounds. So I think there's a lot more questions and more information we need to get before we can even start this process as far as determining whether there's any civil liability or anything else like that. There's a lot of information out there we need to look at first. That would be my suggestion, is to turn this over to LSO for further investigation.
Thank you, Representative Davis. Others? Senator McEwen.
If we're going to go down the criminal path, why don't we take a different approach? Such as, if your cattle are on my land and I notify you, you have 48 hours to get them off, or 24 hours. Then it doesn't become necessarily a fence issue. And if you have good relations with your neighbors, like I'm sure when your cattle get into your neighbor's land, you get them back right away. So maybe if we looked at a time frame versus what type of fence and what happened, it still falls in with the fence out. And you just got 48 hours or 24 hours or whatever the committee's pleasure is, 3 hours, 6 hours, 14 days. But I like the 48 hours with the buffalo, and it would flow together. Thank you, Mr. Chairman.
Senator Pearson.
Thank you, Mr. Chairman. I like having a time frame in there as well, but a herd of cattle, and I'm sure that most of you saw my email, can do a lot of damage on an alfalfa field in 48 hours. I just think that if we have some sort of a penalty in there, that it's going to kind of force livestock producers to manage their livestock better. So there is a lot of discussions that need to be had, and there is a lot of probably more in-depth investigation through LSO on this. But we've got to do something. We've got to do something. And I look to this committee to help me draft something. And it doesn't have to be today. Just help me. Thank you.
Thank you, Senator. Go ahead, Representative Johnson.
Thank you, Mr. Chairman. Just real quick, maybe we should put adverse possession in there. 48 hours, your cows aren't off my land and they're mine.
Senator McEwen.
This is kind of a question for the lawyer at LSO. So if you did the 48 hours, would the damaged alfalfa fall under any vandalism statutes? Or could we rework the vandalism statute so it does, so there is a criminal penalty?
Chairman Ide, Senator McEwen, I'm not entirely sure about the vandalism statutes off the top of my head, but we can look into that.
Senator Love.
Mr. Chairman, thank you. There's an awful lot to digest here when we talk about fencing, and I agree with it. We need to update what a legal fence looks like in Wyoming. We also have other things, especially in the gentleman at Wyo Fresh, who's surrounded by municipality, and municipalities are offered somewhat of an exemption in these situations. And the state's agreed to take on responsibility for their fencing. So government recognizes that that needs to happen and there needs to be some cooperation there, but municipalities still operate somewhat with immunity in this situation. When we talk about a 48-hour time frame and notice, what we then are going to have to identify what legal notice is to the owner of the livestock, and you know what the parameter for delivery of that is, and does it have to be in writing or is it verbal? And if it's verbal, then how do we document the verbal notice? And there's just a tremendous amount of things we're going to have to sort through. And as a state governing body, I think it's important that when we look at what we redefine a legal fence as, that we really need to try to make sure that it fits the majority. And there's no way to write a law that's going to allow for every little nuance and every little species and every little, because your neighbor could decide to go from raising cattle to sheep, and if sheep take a whole different type of fence than cattle do, and then is that because they decided to change their business model, is it now my responsibility to make an acceptable fence to hold out sheep? And so is it, or just, is it on them, right, like it is currently, to change that fence so they keep their sheep in? And so I think a lot of these questions are just things, it's going to take a while to digest all of this and figure out how we work with other agencies and municipalities and governing bodies to identify what this might look like. Because if we start making criminal penalties and liabilities out of it, it's going to get pretty serious for a lot of people. And forever when we talked about paying for half of our fence, when I got a 2-mile fence line in front of me, and I own this 2 miles of fence. And when I look at that 2 miles of fence, I own the right half of that fence. And it doesn't matter if there's one person on the other side or if there's 20 people on the other side, their responsibility is the same thing. When they look at their fence line facing me, they're responsible for the right half of that fence. But that's not in law anywhere. We've never put that down. That's just the way neighbors operated with each other. And we were respectful and mindful of our businesses and good stewards of the land. And, as we talked about wildlife fencing and changing those things, there are little things we can do that help identify some of those things. We used to put 2 strands of wire right down on the bottom of the ground and bring it up. Well, now we know that inhibits, migratory patterns for antelope. And so in order to be responsible for antelope, we've changed that, and we put that bottom wire 14, 16 inches off the ground to make sure their travel corridors aren't blocked. We're diving into something that's a tremendously vast, large conversation, and trying to find something in state law and define something in state law that's going to fit the majority of those situations going to be difficult. Not impossible, and very much something that I believe we need to tackle, because we do have a lot of subdivision issues. We do have a lot of those other things that they're creating. And so let's think about the subdivisions for just a second. My same 2 miles of fence, and Bob across the fence, he's owned that 2 miles of fence, but Bob all of a sudden decides he's going to subdivide a quarter section on on the east side of my place. And so now he puts 20 houses down that side of my fence. And when I'm facing my half of the fence, I've been responsible for the last 25 years for the mile of fence to my right. Well, now I'm responsible for my responsibility moves further west to be half of Bob. And then I have 20 new landowners. When I look at my fence line with them, each of them is responsible for half of their fence that's part of my fence. So I've now divided my responsibility of that quarter section up among 20 people, each responsible for their half of their fence, and I'm responsible for the other half of all those. And then I'm responsible for this new portion of fence that used to be part of my neighbors. And so you can see where this fencing issue can get really big really fast. But I do believe we have to address all of these issues if we want to try to help make good neighbors again, because good fences make good neighbors. And we've gotten to where we don't pay attention to our fences like we should. So thank you, Mr. Chairman.
Thank you, Senator Love. I'll just chime in here now. I think we're getting close. Thinking about this, writing down some notes just to keep things encapsulated here. And I'm not sure the best way to go about it. You know, a draft bill kind of gets everybody excited and everybody's, oh, you can't do this and we got to come scream about that. And I understand everybody's got a horse in the race on this. So for our next meeting, I'm just trying to think of directives for LSO on how we approach this. You know, we've got the big one is, are we going to deal with criminal penalties in this, and how does that look? You know, the federal land border, you know, whether it's the feds, the lessee, how do we deal with that? The bison issue is another bullet point. Representative Davis brought up turtles. We might have to put that in there somewhere. Anyway, you know, it is. It's a heavy lift here. And I don't know if at our next meeting, if we just bring sort of an outline of what this could look like if we do draft some legislation, or if the committee wants to just go to, you know, straight to a draft bill and then we can really start picking away at it. We don't have to vote on anything. We can make amendments. Everybody will have a chance to chime in. Maybe LSO can give us a little direction on what you think this could look like or should look like, or where will we start and where do we finish? Thank you.
Chairman Ide, I think there's probably two different ways you could go about it. We could do some more research, sort of encompassing what you suggested as well as what Representative Davis suggested. The other way to do it might just be to have a working group, and you could all get together, or a certain number of you could get together along with stakeholders and try to determine the best way to go forward. But at the end of the day, it's totally up to the committee what you want to do, but that's what I would suggest, one of those two things.
Okay. Yeah, on that, working groups are good. Everybody's time is limited, I know, but if there is an appetite for that, you know, I'm all ears. If the committee wants to go that direction, or if we want to just start piecing this together through LSO and making our comments and discussing that from there. So anybody have anything to say about that? Yeah, Representative Vaughn.
Thank you, Mr. Chairman, again. We were just thinking also, in order to, who has any enforcement? Like, is there, we've heard, and I've always heard, call the sheriff. But what I'm hearing is, what authority do they have? And they can say move, but do they have, is there any authority? So is that something, and then where we look for the livestock board authority? So just if we could have some information on those two, I'd appreciate that.
Thank you, Representative. Yeah, and on that note, the gentleman that was online, he had a question, who determines, who has the police power to determine what a legal fence is? I don't know if anybody on this committee knows that answer, but I thought it was a pretty good question. Who has that authority to say these, there's only 3 strands, you need 4, and they need to be 18 inches off the ground, and who's responsible for that? Committee. Co-Chairman Banks. Oh, sorry.
Thank you, Mr. Chairman. I think, just from my opinion, we let LSO do the research on this. I think as far as the legal backing and the legal ramifications, will best come from them as far as researching the statutes and different things like that. I think they have the expertise in doing that. And I hate to throw more on your workload, but that is kind of where I'm leaning on it.
Thank you, Co-Chairman. That's sort of my thoughts on that too, is we didn't really collaborate on that as far as being in the chairman hot seat, but just trying to get a consensus with everybody too, and not make too much work on LSO, but not waste a lot of time on a bill that's not going to go anywhere, and we're going to debate it until the cows come home. So not to use that cliche, but yes, Senator Pearson.
Thank you, Mr. Chairman. So also to address Representative Banks, maybe we add in there flagrant trespass or something like that. I mean, and then to answer Representative Ottman's question, our sheriff has repeatedly told us that there is nothing that he can do because there's nothing in statute to address this. So, help me help you. Thank you.
I might just add one thing here, Mr. McGagnon. I hate to keep leaning on you all the time, but you've been around for a long time, and stock growers is pretty influential, and they'll have a large interest in what comes out of this, if anything. And if there's anything you'd like to add to help guide us, so you can have the bench here again. Oh, no, you're okay. Just sit still.
Thought is, or fix one piece of legislation. I'm inclined to bring the focus back to, perhaps bring the focus back to the original issues that led to this becoming a topic, and recognize that some of these others, related to how you deal with municipalities, how you deal, thank you, how you deal with bison and rabbits, and I mean, we could go down a rabbit's hole, if you excuse the pun, but maybe we need to start with something that's more narrowly defined, that addresses the original issue that led to this, and then see if it's appropriate to add some things into it later. But I could see getting such a complex bill that simply don't get through it in time to have anything meaningful to bring to the next session.
I think that's good advice. Go ahead, Representative Strzok.
Thank you. Just a question for you. I just remember at one time, it's always been talked about that, if you have these repeated cattle that keep coming on your place, I know people have loaded them up and that was talked about, taking them to the sale barn. Was that something that they would just do? Is that legal? And this was when I was little. I just remember this discussion happening. So is that something that they?
I
wouldn't admit.
I'd say to just take them to the sale barn. You can get to that. I mean, if you read the current statute, if you have a fence and they continue to breach your fence and they don't come and get them, you can claim those animals to pay for the damages. So I could see a circumstance where you could take some of those animals to the sale barn. You'd have to account for the proceeds, determine the value of the impact to your fence, and then anything above that you'd have to be reimbursed back to the owner of the livestock. But wouldn't be a clean situation, but I could see where you could interpret this statute so as to allow that.
Okay, thank you. I'm not admitting to anything. I just remember that being this funny discussion when I was younger, that could be a possibility. So I just wondered if that was something that.
It really all comes back to the fencing, because this is all based around fencing.
Right.
It's really not about
No, couldn't.
where your livestock go. It's about, is there a fence? Is the fence kept up? Did they pay their fair share of keeping it up? And has the fence been breached by unruly livestock?
And I don't think it was so much that they would take the money because that has that brand inspected on it, but it was just to get these problem livestock away from these people, just get it out. It was a problem. And I'm not saying it happened. I'm just saying, I remember this whole discussion. I know I was way too little. I just was thinking, is that something that was part, just a curious thing here.
Mr. Chairman, may I make a 30-second response?
Absolutely.
To that? That is not legal activity. You're now depriving that owner of his livestock. That's cattle theft. So I would not advise doing that. Under our estray laws, we have ways to deal with that through brand inspection and the estray laws. If we can obtain those animals, we can seize them or take them until such time as that owner comes and gets them. Yeah, or they could be impounded at your place until he comes to get them. But no, don't take them to the sale barn.
Thank you. It was just that thing of what, if you have this person that keeps, won't deal with their livestock, what are is that something like, can we call you and say, hey, we've got this problem. We're done with this. They're in our corrals. Please come do something with them.
Mr. Chairman, quickly, our authority in that case is to come identify ownership. If we can, we'll contact that owner. If without the statute in front of me, if we can't find him or he does not comply, then we can take him. And then we have 10 days to do our game and we can sell him, but you can't.
There's something
Just-
in that.
I'm watching you now, Representative Scott. But that's a fair question, and we have a process for that under the estray. It's similar, or there's a feed lien process. We don't handle that, but there is a feed lien process if you've got them on there where you can take them, hold them, and start applying a feed lien. But that's another civil game. So I'm just telling you that up front. So
in some ways, we do have some things out there.
there's some options. There's some options.
Yes, I'm saying without changing. I'm sorry.
Real quick, yes.
Without us going into, I guess that's part of maybe what they could even research, but there are some options, I guess is what I'm trying to say here, of this repeat customer. Like,
Mr.
So-
Chairman, Representative Strzok, if I might, and it's far from my lane to recommend anything, and so I'm gonna pull something out of the air, maybe take a look at 1128-108, that breach of civil enclosure, and see how you can amend it to get where you want to go. That might be a quicker answer. Domestic bison are already included in that statute for the breach, so there's one of your angles. But I would suggest you take a look at that and see if there's something you can do with that fits where you're going before you open up the whole.
I'm not as dumb as that's all I'm gonna say.
All right, thank you. All right, committee, maybe we, with a few suggestions here, pivot a little bit and try to bring this back into the original conversation of Senator Pearson. And maybe with that, we could get something drafted that we could look at. And I think maybe good communication between Co-Chairman Banks and Senator Pearson. They had pretty strong opinions on how that should look. And then the rest of us could look at that maybe at the next meeting. Does that work with you? Senator Pearson, what do you think? I'm not trying to put something on you, but.
Yes, Mr. Chairman, that sounds good. I would like to add Jim McGagnon into the conversation as well, so. If he's willing. Are you willing? Say yes, just say yes. Thank you.
So any discussion on that for the committee? Would the committee like to see that or not? Give me some direction here and we can actually, I don't know if we're supposed to vote on it. I suppose we are if we want to get something drafted. Do we not have to?
Mr. Chairman, you could just do a voice vote. Quick voice vote.
Okay. Guys ready to vote for, I guess what we're voting on is a draft of some legislation that deals with fencing out and penalties, to put it succinctly, and see what that looks like. And I assume that those criminal penalties would be misdemeanor, and kind of decide on what that, is there a baseline number on misdemeanor that you don't have to change the dollar amount?
Your typical misdemeanor falls between 6 months to 1 year in jail and a $750 fine to $1,000 generally. But we could definitely talk with Chairman Banks and Senator Pearson about what they want with
Okay.
that. So.
Research.
Yeah, go ahead. Yeah, go ahead and bring that up. I'll let you take that one.
Yeah, so I'm leaning more towards let's do the research first before we go through the formal draft. I'm kind of sitting at that, more towards that angle of let's see what research we come up with first to see where we can target the fixes that we need to accomplish. This kind of would be my preference.
And Mr. Chairman, to kind of piggyback on that, we would, in order to actually draft a bill, we'd need a lot more information. So I do think that it might be better just to start with the research and then go from there.
Now, is that the research on just what we've pared it down to criminal penalties and the fence out, fence in part of this?
We have a few things that we listed. If you just want us to focus on that, we can. But we could just look at fence in, fence out, and criminal penalties. But it's up to the committee, so.
Committee, any opinion? Do we want to go through the whole smorgasbord for the research before we discuss any of it? Or do we want to refine this down to the Senator Pearson, Dalton Banks criminal penalties and what the fence in, fence out stuff would look like or change? Any comments? Senator Pearson?
Thank you, Mr. Chairman. So I think that we need to focus on one thing at a time, honestly. So basically why this was brought as an interim topic, and, you know, also adding in, and I don't know if LSO wrote this down as far as federal leases, you know. I mean, that would be my preference. I think that would be easier rather than trying to focus on all of the other things as well. We could talk about those later, maybe the subdivisions and the municipalities and things like that, because technically we have to do one subject at a time, right? Wouldn't that be like 3 or 4 different bills to focus on all of those different entities? Thank you.
Mr. Chairman, Senator Pearson, it really kind of depends. Depending on what you want to do, it could potentially all fit under one subject, but like you said, it could become complicated trying to fix all of those problems at once and might actually end up needing more than one bill.
All right, committee. I think sort of what was proposed was to keep it narrow and take a look at that. We can wade in. I think LSO kind of has notes on all of the other stuff that we're contemplating as well. But for now, keep this focused on the issue, and we'll go ahead and take a vote. All those in favor say aye. Opposed? Okay, we'll get something drafted. Further discussion from the committee. Co-chairman, you want to add?
Mr. Chairman, sorry. Just to clarify, you want a memo at this point, a research memo at this point, not a draft bill.
Co-chairman? I think that would probably be good. And then that would, so if we've got 2 more meetings, right?
Mhm.
So if we have a memo at the next meeting, we could potentially draft a bill for the next one to vote on if we wanted to get it to the 2027 general session. Is that correct?
Yes, Mr. Chairman. we can
Okay,
do
so
that.
let's do that then.
Okay.
If everybody's okay with that, we'll get a memo, kind of get all the thoughts on paper, and we can discuss that and then draft a bill. Sound good? Okay. Anything else? LSO, do you have any comments for us, questions before we make a motion to adjourn?
Mr. Chairman, no, I think we're good. Thank you.
Okay. Anybody else in the audience? All right. I'll entertain a motion to adjourn. All those in favor say aye.
Aye.
Opposed? We're adjourned.